on Social Security Central Rules, 2020. The Ministry of Labour and Employment established comprehensive Social Security regulations to provide healthcare, pensions, and insurance protections for all Indian workers regardless of employment type. These landmark rules standardize benefits across diverse work sectors by consolidating 9 previous legislations into a unified code, representing one of the most significant overhauls of India's labor welfare system in decades. Below are frequently asked questions regarding the Code on Social Security. What is the Code on Social Security? A comprehensive regulatory framework ensuring workers receive essential benefits including healthcare, pensions, and insurance across all employment categories in India. The Code strategically consolidates and replaces multiple existing labor laws to create a more efficient and accessible system. Who developed these regulations? The Ministry of Labour and Employment formulated these rules following extensive consultations with key stakeholders, including employers' associations, trade unions, and state governments to ensure balanced and practical implementation. Which workers are covered? The Code extends protection to workers across all sectors, including those in traditional employment, factories, offices, and remote workers. Significantly, it brings gig workers, platform workers, and those in the unorganized sector under Social Security coverage for the first time in Indian labor history. Why is this reform significant? This legislation ensures universal basic protections and benefits for all workers, regardless of sector or employment type, providing crucial financial security during emergencies, illness, disability, and retirement. When does implementation begin? While the code received parliamentary approval in September 2020, with detailed rules notified in November 2020, implementation follows a phased approach allowing organizations sufficient time to adapt their systems and compliance processes. What specific benefits does the code provide? The legislation encompasses employee insurance, provident funds, gratuity payments, maternity benefits, and compensation for work-related injuries or illnesses. Additionally, it establishes dedicated Social Security funds for workers in the unorganized sector. How will the government ensure compliance? The code establishes specialized authorities and robust inspection systems to monitor employer compliance. Non-adherence can result in substantial penalties, while digital initiatives facilitate simplified compliance through unified filings. This landmark legislation represents a transformative step toward achieving universal Social Security coverage in India, simultaneously protecting the nation's diverse workforce while streamlining compliance requirements for businesses through technological innovation and administrative consolidation. Ministry of Labour and Employment notification. The November 2020 official notification established comprehensive Social Security Code rules under governmental authority, consolidating 9 previous regulations through powers granted by specific legislative provisions. Frequently asked questions. FAQs. Key information about the official notification for the Code on Social Security Rules, 2020. When was the notification issued? The notification, GSR 713-E, was officially published in New Delhi on November 13, 2020. What legislative authority enables these rules? The central government derives its authority from Sections 154, 155, and 158 of the Code on Social Security, 2020. In conjunction with Section 24 of the General Clauses Act, 1897. How do these rules affect previous regulations? These new rules supersede and consolidate 9 previous regulations, including the Employee State Insurance Central Rules, 1950 and the Tribunal Procedure Rules, 1997. What is this notification's primary purpose? This notification formally establishes and implements the Code on Social Security Central Rules, 2020, creating a unified framework for Social Security provisions across India's diverse employment sectors. Which governmental body oversees these regulations? The Ministry of Labour and Employment holds primary responsibility for the development, implementation, and administration of these comprehensive rules. Who are the intended beneficiaries? These rules extend standardized Social Security benefits to all worker categories, including those in organized and unorganized sectors, gig workers, platform workers, and contract laborers. What key protections do these rules provide? The rules ensure essential protections including healthcare access, maternity benefits, disability coverage, retirement security through pension schemes, and comprehensive workplace injury insurance. This landmark notification represents a cornerstone of India's labor reform initiative, streamlining complex labor regulations while extending vital social security protections to previously vulnerable and excluded worker populations. FAQs about the notification process. The government facilitates public participation through a comprehensive 45-day consultation period on draft notifications, offering multiple submission channels with standardized format requirements. This transparent approach ensures meaningful stakeholder involvement in the regulatory development process. How long is the public consultation period? The public is granted a 45-day review period following the draft's publication in the Official Gazette. This window allows all stakeholders to submit feedback, comments, and suggestions on the proposed rules. The extended time frame ensures thorough analysis of potential implications and development of comprehensive responses. When does the consultation period begin? The consultation period commences immediately upon publication of the draft notification in the Official Gazette. The official publication date is clearly indicated on the notification document, serving as the starting point for calculating the 45-day consultation window. How can I submit my feedback? Stakeholders may direct their suggestions to Shri Rahul Bhagat, Director, Ministry of Labor and Employment through any of these official channels. In-person submission. Room number 302, Shram Shakti Bhawan, Rafi Mart, New Delhi. 110,001 electronic submission. rahul.bhagat@ipes.gov.in postal correspondence. Forward written comments to the address specified above. Facsimile 011-2376-6903. What format should I use for my submission? To ensure proper consideration and processing of your feedback, please include all of the following essential information: full name and complete contact address, organizational affiliation, if applicable, specific reference to the chapter, section, and rule number addressed in your comments. Proposed alternative wording. When suggesting amendments, comprehensive rationale and justification for your recommended changes, relevant supporting evidence, research findings, or illustrative examples that strengthen your position. Will I receive confirmation of my submission? While individual acknowledgements may not be issued for all submissions, the Ministry assures that all properly formatted feedback received within the designated 45-day time frame will be documented and thoroughly evaluated during the review process. What happens after the consultation period ends? Upon conclusion of the consultation period, the Ministry conducts a comprehensive review of all submitted feedback. Appropriate and viable suggestions may be incorporated into the final rules prior to official publication. The final notification will subsequently be issued in the Official Gazette, at which point the rules become legally binding and enforceable. Frequently asked questions. Social Security Code. The Code on Social Security Rules establishes comprehensive definitions and implementation guidelines for India's Social Security framework, with nationwide applicability following official publication in the Gazette. What are these rules called and where do they apply? These rules are officially titled the Code on Social Security Central Rules, 2020. They have jurisdiction across the entire territory of India, including all states and union territories, and become effective upon their publication in the Official Gazette. These rules operationalize the provisions outlined in the Code on Social Security, 2020. When will these rules come into effect? The rules become legally enforceable from the date of their final publication in the Official Gazette. This publication serves as the formal notification that the rules are now binding and must be implemented throughout India. What kind of definitions do these rules provide? The rules offer precise explanations for critical terminology including agency, appeal, authority, average daily wages, financially independent, family register of women employees, nomination, residence, specified authority, and other technical terms to ensure consistent interpretation and application. Why are these definitions important? Comprehensive definitions eliminate ambiguity and ensure all stakeholders clearly understand their rights and obligations under the Social Security Code. They provide legal certainty and enable uniform interpretation of provisions across diverse situations and contexts. Who is responsible for implementing these rules? The central government, operating through the Ministry of Labor and Employment, holds primary responsibility for nationwide implementation. States and union territories also play crucial roles in executing these rules within their respective jurisdictions. How do these rules benefit workers? These rules safeguard workers by establishing robust guidelines for Social Security benefits, encompassing pension schemes, maternity benefits, gratuity payments, and compensation for work-related injuries. They create a comprehensive safety net for employees across diverse economic sectors. What should employers know about these rules? Employers must understand their statutory obligations regarding employee registration procedures, contribution requirements, record-keeping standards, and compliance reporting protocols. Non-compliance may result in significant penalties as stipulated in the Code on Social Security, 2020. Frequently asked questions about key terms. This section clarifies essential legal terminology in the Social Security Code, covering administrative entities, procedural mechanisms, and calculation methods to ensure consistent implementation and understanding. What is an agency under the Code? An agency refers to any organization established by parliamentary legislation, including government-owned companies and special entities officially designated by the central government through formal notification. These agencies serve as implementing bodies for various provisions of the Social Security Code. What does appeal mean in this context? An appeal represents a formal request for review of a decision as permitted under Section 23(1) of the Code. This procedural safeguard enables affected parties to challenge determinations, submit additional evidence, and present further arguments to ensure just outcomes. Who is the appellate authority? The appellate authority is the designated review body that may be the central government itself, a central government appointee under Section 56(8), or a state government appointed officer. This authority possesses jurisdiction to confirm, alter, or overturn the original decision after examining the merits of an appeal. How are average daily wages calculated? Average daily wages are determined by summing all wages earned during a contribution period and dividing by the number of days for which these wages were paid. This calculation method ensures benefits accurately reflect actual earnings and provides a standardized basis for compensation determinations. What is the definition of authority in the Code? Authority denotes any individual or body appointed by the central government to administer specific functions under the Social Security Code, including officials responsible for registration processes, monitoring compliance requirements, and enforcing statutory provisions throughout the implementation framework. What constitutes building or construction work? Building or construction work encompasses construction, alteration, repairs, maintenance or demolition of structures including buildings, transportation infrastructure, roads, railways, runways, utility projects, irrigation, drainage, flood control, power generation and distribution systems, waterworks, oil and gas installations, and comparable development projects. What does Career Center refer to? A career center is an office established by either central or state government that provides comprehensive employment services, including registration assistance, information dissemination regarding vacancies, vocational guidance programs, and personalized career counseling to support workforce development. How is continuous service defined? Continuous service denotes uninterrupted employment that includes authorized absences such as paid leave, temporary layoffs, or participation in legitimate strikes. An employee maintains continuous service status when working for the same employer for a specified duration without significant employment interruptions. Frequently asked questions. Exemption from Chapters 3 and IV. Employers can request exemption from Chapters 3 or IV through electronic applications, with decisions typically rendered within 60 days. Applications receive automatic approval if no decision is issued within this time frame, though specific eligibility criteria must be met for consideration. How can an employer apply for exemption from Chapter 3 or IV? Employers seeking exemption must submit an electronic application to the Central Provident Fund Commissioner or the Director General. The application should include comprehensive documentation demonstrating how alternative arrangements meet or exceed the standards established by the Code. What specific information must be included in the exemption application? A complete application should include detailed company information, specific justification for the exemption request, thorough description of alternative arrangements or enhanced benefits being offered, and supporting evidence that clearly demonstrates how these alternatives fulfill the fundamental objectives of the Code. How long does it take to get a decision on the exemption request? Officials are required to render a decision within 60 days of receiving a complete application. Throughout this evaluation period, your establishment must maintain full compliance with all provisions outlined in Chapters 3 and IV. What happens if I don't hear back within 60 days? If authorities fail to communicate a decision within the 60-day window, your exemption request is automatically deemed approved under the Deemed Approval provision. Nevertheless, we recommend following up with the relevant authorities to secure formal documentation confirming this approval. Are there any limitations on applying for exemption? The provisions must apply under subsection 4 of Section 1. Your establishment must have been covered by the code for at least 5 years. All required returns and payments must be fully submitted, and up to date your establishment must maintain a record free of significant non-compliance with labor laws. Can an approved exemption be revoked? Yes, authorities retain the right to revoke an exemption if they determine that the qualifying conditions have materially changed, or if the employer fails to maintain the alternative arrangements that originally justified the exemption approval. Is there a renewal process for exemptions? Exemptions are generally granted for a specified duration. Prior to expiration, employers must submit a renewal application following the same process as the initial request. This renewal application should demonstrate continued adherence to the approved alternative arrangements and ongoing compliance with all applicable requirements. Income of dependent parents. Frequently asked questions under the code. Parents earning up to $9,000 monthly qualify as dependents. This provision applies to both biological parents and in-laws of women employees, determining eligibility for various benefits. Frequently asked questions. What is the monthly income limit for dependent parents? Parents with monthly income up to $9,000 from all sources including pensions, investments, rental income, and other revenue qualify as dependents under the code. Which family members are covered under this rule? This provision applies to biological parents and, in the case of women employees, fathers-in-law and mothers-in-law. This inclusion acknowledges the extended family structures common in many households. Why is there an income limit for dependent parents? The income threshold helps identify family members who genuinely require support and qualify for benefits. This ensures benefits target families with actual financial dependency rather than simply relationship status. What happens if a parent's income exceeds $9,000? Parents earning more than $9,000 monthly will not qualify as dependents under the code, potentially affecting the employee's access to certain Social Security provisions and entitlements. How is the income of dependent parents verified? Employers typically request a self-declaration from employees claiming dependent parents. In certain cases, supporting documentation such as income certificates or pension statements may be required to confirm eligibility. Are there any exceptions to this income limit rule? The code does not currently provide explicit exceptions to the $9,000 threshold. However, parents with disabilities or requiring specialized medical care may receive special consideration, with such cases evaluated individually by relevant authorities. Do both parents' incomes count separately or together? Each parent's income is assessed individually. If one parent earns above $9,000 while the other earns below this amount, only the parent with income below $9,000 would qualify as dependent. Is the income limit subject to periodic revisions? Yes, the $9,000 threshold may be periodically adjusted by government authorities to reflect inflation and economic changes. Employees should remain alert to announcements regarding such revisions. Registration of establishments. Frequently asked questions. Establishments must register online through the Shram Suvidha portal, receive certification within 7 days, and maintain compliance to prevent expiration after 24 months. Understanding the registration process is essential for all employers. Below are comprehensive answers to frequently asked questions about establishment registration under the Labor Code. Basic registration process. How do I register my establishment? Complete the online registration form on the Shram Suvidha portal. Submit your business details and required documentation through this fully electronic, paperless system. You'll need to provide your business name, location, industry classification, employee count, and contact information. What documents are required for registration? Required documentation includes business incorporation certificates, address verification, employer identification proof, tax registration documents, and work activity details. All documents must be scanned and uploaded according to the specified format guidelines. Is there a fee for registration? Yes, registration fees are assessed based on your establishment size. The complete fee structure is published on the Shram Suvidha portal. Multiple online payment options are available, including credit debit cards and net banking services. How long does it take to get registered? Your registration certificate will be issued online within 7 days of complete document submission. If your application remains unprocessed after 7 days, your establishment automatically receives registered status under the deemed approval provision. Certificates can be downloaded and printed directly from the portal. I already have a registration. What should I do? Previously registered establishments need only update their information on the Shram Suvidha portal when officially notified. Your existing registration remains valid throughout the transition period until the specified migration deadline. Maintaining registration. Can my registration expire or be cancelled? Registration expires after 24 months of non-compliance with requirements. Additionally, providing inaccurate information may result in cancellation. Before any cancellation action, you'll receive a show cause notice with at least 30 days to present your case. How do I renew my registration? Initiate renewal by logging into the Shram Suvidha portal at least 60 days prior to expiration. Update any modified information, submit your renewal application, and pay the applicable fee. Early submission prevents any disruption to your establishment's registered status. What happens if I make changes to my business? Significant business changes including ownership transfers, location changes, or business nature modifications must be updated on the portal within 30 days of implementation. Failure to report these changes may trigger penalties or registration cancellation. Is there any exemption from registration for small establishments? While registration is generally mandatory for all establishments with employees, certain micro-enterprises or specific categories may qualify for modified requirements. Consult the portal for exemptions applicable to your particular business circumstances. Central Board Administration. Common questions. The Central Board manages funds according to government guidelines, maintains appropriate bank accounts, allocates funds exclusively for member payments, and charges all investment expenses directly to the funds. How does the Central Board manage funds? The Central Board administers all funds in accordance with central government guidelines. It establishes necessary bank accounts to effectively segregate and manage various transaction types. All funds are deposited only in authorized financial institutions including the Reserve Bank, State Bank of India, or other approved scheduled banks. The board implements comprehensive record-keeping for all financial transactions, ensuring operational transparency. Independent audits are conducted regularly to verify compliance with financial regulations. Investment decisions follow rigorous protocols designed to optimize returns while maintaining appropriate security standards. What happens to investment expenses and losses? All investment-related costs and any incurred losses are charged directly to the funds themselves. This ensures that the funds, not external sources, bear these financial responsibilities. Investment expenses typically include brokerage fees, transaction costs, and professional management fees. The board maintains meticulous expense records to ensure complete accountability. Comprehensive breakdowns of all fund-related expenses appear in published annual reports. Can the funds be used for any purpose? No. The funds are restricted exclusively to payments for members, their nominees, or legal representatives as stipulated in the scheme rules. Any diversion of funds to other purposes is strictly prohibited. This limitation safeguards the fund's primary purpose of protecting member interests. Unauthorized use of funds constitutes a violation of guidelines and triggers potential penalties. Regular internal audits verify that all disbursements comply with these strict usage requirements. Who decides how the funds are managed? While the Central Board makes fund management decisions, these must align with central government guidelines. The board has no authority to operate outside these established parameters. Regular board meetings review investment strategies and evaluate fund performance. Specialized investment committees provide expert recommendations to guide board decisions. All significant decisions require thorough documentation and evidence-based justification. The central government periodically updates guidelines to address evolving economic conditions. How is fund performance monitored? The Central Board implements robust performance metrics to evaluate investment returns against industry benchmarks. Detailed quarterly reports analyze fund performance and identify potential concerns. Independent financial advisors provide objective assessments of investment strategies and outcomes. Members receive transparent updates regarding the financial health and performance of their funds. What safeguards exist to protect the funds? Multiple oversight layers include internal controls, independent audits, and governmental supervision. Strict duty segregation prevents any individual from exercising complete control over financial transactions. Advanced security protocols safeguard electronic records and financial operations. Comprehensive insurance coverage provides additional protection against specified risks. Strategic diversification minimizes exposure to individual investments or market sectors. Frequently asked questions. Key information about the Executive Committee explained clearly. The Executive Committee functions under the Central Board's authority with balanced representation from government, employers, and employees. Members are selected through a formal democratic process, serve defined terms of 2 to 4 years, and support the board in executing its diverse responsibilities. Who sits on the executive committee? The committee comprises representatives from all key stakeholders to ensure balanced governance. A central government-appointed chairperson who guides the committee's work and strategic direction. Central government representatives, typically senior officials with relevant policy expertise. Employer organization delegates who bring crucial business and industry perspectives. Trade union and employee association representatives, who advocate for workforce interests. The Central Provident Fund Commissioner, serving as a permanent member with operational insight. Subject matter experts invited for specialized guidance on specific matters when required. How are committee members elected? The Central Board Chairperson convenes a dedicated meeting for elections following a transparent democratic process. Qualified stakeholders nominate candidates for available positions. Each nomination requires a second from another eligible member to proceed. Secret ballot voting ensures fairness and confidentiality in the selection process. Results are declared according to established governance protocols. Both employer and employee representatives are selected through this method to maintain balance. The chairperson holds the decisive vote in case of ties. Election outcomes are officially documented in meeting minutes and distributed to all stakeholders. What does the executive committee do? The committee fulfills critical functions under the Central Board's guidance, conducts preliminary analysis and review of proposals before board consideration, executes specific board-assigned tasks, including compliance investigations, establishes specialized subcommittees to address particular focus areas, conducts quarterly reviews of financial performance and investment strategies, identifies operational inefficiencies and recommends evidence-based improvements, assesses policy implementation effectiveness, and proposes strategic adjustments, facilitates stakeholder engagement to gather insights and address concerns, develops comprehensive reports with recommendations for board review and approval. How long do committee members serve? Term lengths vary according to position and responsibility level. The chairperson, vice chairperson, and trustees serve 4-year terms to ensure leadership stability. Regular committee members serve 2-year terms to balance continuity with fresh perspectives. Reappointment is typically limited to 2 consecutive terms to encourage renewal. Mid-term vacancies are filled through special elections for the remaining period. Members absent from 3 consecutive meetings without valid justification may face replacement. A 1-month overlap period enables knowledge transfer between outgoing and incoming members. Term extensions require exceptional circumstances and appropriate authorization procedures. Employee State Insurance Corporation. The Employee State Insurance Corporation is a statutory government body that delivers comprehensive social security benefits to India's workforce. With balanced representation from state governments and parliament members, it operates under strict procedural guidelines for official documentation and authentication, serving as a cornerstone institution in India's social welfare framework. Who represents states in the corporation? Each state government nominates 1 representative to the corporation, ensuring equitable geographic representation across India. The Lok Sabha, lower house of parliament, elects 2 members to the corporation, providing democratic oversight and accountability. The Rajya Sabha, upper house of parliament, elects 1 member, ensuring state interests are represented at the federal level. This carefully balanced representation ensures diverse regional and constituency needs are considered in all policy formulations. Members typically include distinguished individuals with expertise in labor welfare, social security systems, and public administration. How does the corporation authenticate official documents? The corporation maintains an official seal under the custodianship of the Director General, who bears responsibility for its safekeeping and appropriate application. For document authentication, this seal must be affixed in the presence of either the Director General or 2 standing committee members who serve as official witnesses. These witnesses must countersign the document to validate the sealing process, ensuring authenticity and preventing unauthorized use. The seal displays the official ASIC emblem and serves as the recognized mark of the corporation's legal authority. All contracts, agreements, and significant financial decisions require this formal authentication process before implementation. What is the Employee State Insurance Corporation? It is a statutory body that administers comprehensive social security benefits for workers in India's organized sector. It provides integrated healthcare services and financial protection during illness, maternity, disability, and other contingencies for registered employees. Established under the ESI Act of 1948, it operates one of India's most extensive and inclusive social security networks. The corporation maintains its own extensive healthcare infrastructure, including hospitals, dispensaries, and specialized medical centers nationwide. It operates on a contributory funding model, collecting premiums from both employers and employees to sustain its insurance schemes. Benefits encompass medical care, sickness compensation, maternity support, disability assistance, and dependent benefits in cases of work-related mortality. When and why was the ESIC established? The ESIC was formally constituted in 1952 following the enactment of the landmark ESI Act in 1948. It was strategically created to provide social security protection to industrial workers during India's critical post-independence industrialization phase. Initially focused on factory workers, the scheme has progressively expanded its coverage to encompass numerous additional employment sectors. Its establishment represented India's commitment to upholding worker welfare and implementing international social security principles. How is the ESIC funded? The scheme operates through a tripartite contributory system, with employers providing 3.25% of wages as their share. Employees contribute a more modest 0.75% of their wages toward the program. State governments contribute 1/8 of the expenditure on medical services within their respective jurisdictions. These contributions are consolidated into a centralized ESIC fund that finances all benefit disbursements and administrative operations. The ESIC Standing Committee combines government appointees and elected members who serve 2-year terms, following a structured election process that ensures seamless governance and effective administration of the corporation's extensive Social Security operations. Common questions about ESIC Standing Committee. Who makes up the Standing Committee? The committee comprises a central government-appointed chairperson, 3 members directly appointed by the central government, 3 representatives from state governments, and 8 members elected by the corporation. This carefully balanced structure ensures diverse stakeholder representation, enabling comprehensive decision-making that addresses multiple perspectives within India's social security framework. How are members elected to the Standing Committee? The corporation chairperson initiates the election process by inviting nominations. When nominations exceed available positions, members cast ballots containing exactly the number of names as vacancies. Candidates receiving the highest votes secure positions on the committee. The Director General oversees this transparent democratic process as returning officer, ensuring procedural integrity and fair representation. How long do Standing Committee members serve? Elected members hold office for 2 years from their election announcement date. Importantly, they continue serving beyond term expiration until successor elections, preventing administrative gaps and ensuring uninterrupted governance. This continuity mechanism safeguards the corporation's ability to deliver consistent services to insured workers, even during transitional periods. What are the main responsibilities of the Standing Committee? The committee oversees the corporation's day-to-day operations, executing functions specified by regulations. Its core duties include financial oversight, expenditure approval, scheme implementation monitoring, and policy recommendations to the full corporation. Through regular meetings, the committee ensures the seamless operation of ESIC's diverse social security programs across the country. Can Standing Committee members be removed before their term ends? Yes, premature removal occurs under specific circumstances, when a member misses 3 consecutive meetings without authorization, loses eligibility to represent their constituency, or exhibits conduct deemed harmful to the corporation's interests. Well-established removal protocols protect the committee's integrity and ensure all members uphold their responsibilities to stakeholders. The Medical Benefit Committee advises on local committees, establishes healthcare standards, recommends appropriate medical benefits and medications, and provides guidance on professional conduct to ensure quality healthcare delivery for all insured members. Medical Benefit Committee. Frequently asked questions. What does the committee advise on? The committee guides the corporation in establishing local committees that facilitate medical benefit delivery to members. They define these local groups' scope of responsibilities, authority limits, and operational procedures, ensuring they function effectively within the established policy framework. What recommendations does the committee make? The committee determines appropriate medical benefits and medication protocols for members based on evidence-based research, cost-effectiveness analyses, and patient needs assessments. They also establish illness certification standards and develop preventive healthcare initiatives to improve overall member well-being. How does the committee handle doctor conduct? The committee establishes professional standards and ethical guidelines for doctors providing medical benefits. They monitor compliance, review reported concerns, and recommend appropriate interventions when necessary to maintain high-quality patient care and professional integrity throughout the healthcare network. How often does the Medical Benefit Committee meet? The committee convenes quarterly for regular sessions, with additional special meetings as urgent matters require. The chairperson, in consultation with committee members, schedules these meetings to maximize participation and ensure thorough deliberation of all agenda items. Who serves on the Medical Benefit Committee? The committee comprises medical professionals, healthcare administrators, and insured member representatives, creating a balanced team with both clinical expertise and beneficiary perspective. Members are selected based on their relevant experience, specialized knowledge, and ability to represent key stakeholder interests. What role does the committee play in quality assurance? The committee implements comprehensive quality monitoring systems with established performance metrics and outcome evaluations. They conduct regular service assessments, identify improvement opportunities, and recommend enhancement strategies to maintain exceptional care standards across all medical facilities serving insured members. How does the committee address specialized healthcare needs? The committee develops targeted recommendations for members with complex health requirements, including chronic conditions, disabilities, and occupation-specific health concerns. They ensure the medical benefits system provides appropriate accommodations, specialized treatments, and accessible care options for all members regardless of their unique healthcare needs. National Social Security Board. Common questions. The National Social Security Board for Unorganized Workers comprises diverse stakeholders, implements term limits to ensure fresh perspectives, and mandates representation of disadvantaged groups to promote inclusive policy development. Here are comprehensive answers to frequently asked questions about the National Social Security Board for Unorganized Workers. What is the National Social Security Board? The National Social Security Board for Unorganized Workers is a specialized body established to formulate policies and recommend welfare measures for workers in the unorganized sector. These workers typically lack formal employment relationships and traditional Social Security protections, making the board's role crucial in addressing their unique needs. How long can someone be a board member? Members are appointed for a term of up to 3 years. They may be reappointed, but cannot serve more than 2 consecutive terms. This governance structure balances the need for continuity with the importance of introducing fresh perspectives and ideas. Who sits on the board? The board features a diverse composition including representatives of unorganized workers, employers, subject matter experts, members of parliament, and officials from central government, state governments, and union territories. This multi-stakeholder approach ensures comprehensive representation in the decision-making process. Does the board ensure fair representation? Yes. The board's composition includes mandatory representation from scheduled castes, scheduled tribes, minorities, and women. This deliberate inclusivity ensures that historically marginalized groups have meaningful participation in policies affecting their welfare and social security. What are the main functions of the board? The board's key responsibilities include recommending tailored welfare schemes for various categories of unorganized workers, monitoring implementation of existing programs, advising on extending Social Security coverage, and developing innovative initiatives to enhance worker welfare. How often does the board meet? The board convenes at least 3 times annually. Additional special sessions may be called when urgent matters arise that require immediate attention and deliberation. Can the board create schemes on its own? No. The board functions primarily in an advisory capacity. While it makes substantive recommendations to the central government, which retains implementation authority, the board's expert guidance significantly influences policy formulation and program design. How does the board identify unorganized workers? The board collaborates with various government agencies and stakeholders to systematically identify and categorize different types of unorganized workers. This identification process encompasses workers across diverse informal sectors including agriculture, construction, domestic services, street vending, and numerous other unstandardized occupations. Frequently asked questions about the National Social Security Board. The National Social Security Board comprises 15 members representing companies, gig workers, and subject experts, established to support welfare initiatives with members serving limited terms of up to 3 years each, not exceeding 2 consecutive terms. Here are comprehensive answers to common questions about the National Social Security Board for gig workers. What is the National Social Security Board for gig workers? This specialized board was established to facilitate Social Security benefits and protections for gig and platform workers. Members serve terms of up to 3 years, with a maximum of 2 consecutive terms permitted, ensuring both continuity and regular introduction of fresh perspectives. Who comprises the board? The central government appoints 15 members to the board, 5 representatives from companies employing gig workers, 5 gig and platform workers, and 5 subject matter experts in worker welfare, management, law, e-commerce, or information technology. This tripartite structure ensures balanced representation of all stakeholders in the decision-making process. How does the board support gig workers? The board may constitute specialized expert committees to advise on gig worker welfare, conduct demographic assessments, and identify emerging platforms employing these workers. Additionally, the board recommends tailored policies and programs to enhance Social Security benefits that address the unique challenges faced by gig workers. What is the board's meeting schedule? The board convenes quarterly, with provisions for additional meetings when urgent matters arise. All proceedings are meticulously documented for transparency and archival purposes. What is the scope of the board's authority? The board functions primarily in an advisory capacity to the government. While it cannot enact legislation independently, its recommendations substantially influence policy formulation regarding gig worker welfare and Social Security provisions. How is board membership determined? Members are selected through a rigorous nomination and evaluation process overseen by the central government. Candidates are assessed based on their relevant expertise, experience, and capacity to effectively represent their respective stakeholder constituencies. Does the board address individual grievances? Although the board typically does not intervene in individual cases, it establishes guidelines for grievance redressal mechanisms and recommends enhancements to existing frameworks for addressing worker concerns. For additional information regarding the National Social Security Board for Gig Workers, please contact the Ministry of Labor and Employment. Common questions about board functions. The board establishes specialized committees, maintains a 6-month transition period between terms, processes member resignations through formal written notice, and fills vacancies through government appointments for the remainder of the term. Additionally, the board implements transparent administrative procedures and ensures accountability in all decision-making processes. Here are comprehensive answers to frequently asked questions about the board's operational procedures. How does the board form committees? The board establishes specialized committees to investigate specific issues or implement targeted programs. These committees may include both board members and external subject matter experts as needed. Each committee must include at least one board member who serves as a liaison and provides regular updates to the full board. What happens during board transition periods? The government initiates the formation of the new board 6 months before the current board's term expires. This carefully planned transition period ensures operational continuity and knowledge transfer. If the new board appointment process faces delays, the government implements temporary arrangements to maintain uninterrupted essential services. What is the process for board member resignation? Members can resign by submitting a formal written letter to the government through official channels. The position becomes vacant upon government acceptance of the resignation, or automatically after 30 days from receipt of the letter, whichever occurs first. Resignation letters should include the effective date and, optionally, the reason for departure. How are board vacancies filled? The member secretary formally notifies the government about any vacancy within 7 working days of its occurrence. The government then appoints a replacement to serve for the remainder of the original member's term. During the interim period, the board continues to function with its remaining members to ensure continuity. What is the board's meeting schedule? The board convenes quarterly at minimum, with at least 1 meeting every 3 months. The chairperson may call additional special meetings to address urgent matters requiring immediate attention. A quorum of at least 8 members must be present for any meeting to be considered official and for decisions to be binding. Is there a review process for board decisions? Yes, board decisions can be reviewed if 1/3 or more of the members submit a formal written request within 30 days of the decision. Furthermore, certain categories of decisions may undergo review by designated government authorities according to established regulatory frameworks and procedural guidelines. How does the board maintain transparency? The board publishes comprehensive annual reports detailing its activities, key decisions, and financial statements. Meeting minutes are meticulously documented and made accessible to relevant stakeholders. Additionally, the board maintains a public-facing website where important notifications, policy decisions, and upcoming initiatives are regularly published and updated. For additional information regarding board procedures or to request further clarification on any topic, please contact the office of the member secretary using the contact details available on the official government website. FAQs, Construction Workers Welfare Schemes. Construction workers can access comprehensive benefits including group insurance, educational support for children, medical assistance, and various government schemes for housing, skills training, and retirement security through welfare board programs. What insurance benefits can construction workers get? Construction workers receive group insurance coverage with premiums paid by the State Welfare Board. Benefits include accidental death coverage up to 2 lakhs, partial disability compensation, and funeral assistance. To qualify, workers must maintain active registration with the board, providing essential financial protection for themselves and their families during emergencies. How does the board help with children's education? The board offers comprehensive educational support through school fee coverage, merit scholarships, and textbook allowances. High-performing students receive additional merit scholarships, while vocational training subsidies are available for older children. The program includes special incentives for female education and substantial grants for students pursuing professional degrees in fields like engineering and medicine, creating pathways to better opportunities. What kind of medical help is available? Workers and their families receive financial support for serious health conditions, including hospital stays, surgeries, and major treatments. The program encompasses preventive health checkups, maternal care benefits, and coverage for chronic diseases. Through the board's network of empaneled hospitals, treatment costs are directly settled, significantly reducing financial burden and improving healthcare access. Can workers get other types of welfare support? Absolutely. The central government regularly develops new welfare initiatives to address evolving needs. Current programs include subsidized housing loans, rental assistance, and home renovation grants. The board also facilitates access to major government housing initiatives like the Pradhan Mantri Awas Yojana, creating multiple pathways to housing security for construction workers. How can workers access pension and retirement benefits? The Welfare Board administers specialized pension schemes requiring a minimum contribution period of 5-10 years. Upon reaching retirement age, typically 60, workers receive monthly pension benefits scaled to their years of service and contribution history. Additional retirement security includes a one-time gratuity payment and senior citizen healthcare packages, ensuring dignity and support in later years. What skill development opportunities are available? Workers can enhance their employability through board-sponsored certification programs in masonry, carpentry, plumbing, electrical work, and heavy equipment operation. The board covers all training expenses and provides stipends to offset income loss during training periods. These programs often include job placement assistance upon completion, directly translating improved skills into better wages and job security. Social Security Organization meetings. Frequently asked questions. Various committees meet 2-4 times annually with 15-day advance notices. Quorum requirements range from 6-15 members depending on committee type. Meetings follow specific location protocols and documentation standards to ensure proper governance. How often do different committees meet? The Central Board meets at least twice yearly, June-December. Executive and standing committees meet quarterly. The Medical Benefit Committee meets twice yearly, January-July, and the National Social Security Board meets 3 times annually, April, August, December. Special meetings may be convened for urgent policy matters. How much notice is given before meetings? Members receive detailed notices at least 15 days before scheduled meetings, including date, time, location, and agenda with supporting documents. For urgent matters, emergency meetings require a minimum 3-day notice. All communications are sent via official email and registered post to ensure receipt. How many members must attend for a meeting to be valid? Quorum requirements vary by committee. Central Board needs 11 trustees including employer and employee representatives. Corporation requires 15 members with balanced representation. National Social Security Board for unorganized workers needs 10 members including 3 state representatives, and the Board for gig workers requires 6 members, with at least 2 platform representatives. Where are the meetings typically held? Central Board and corporation meetings occur at headquarters in the capital city, while regional committee meetings rotate between state offices to enhance participation. Issue-specific meetings may be held in the concerned region. Virtual meetings with proper documentation are permitted during emergencies. What happens if quorum requirements aren't met? If quorum isn't achieved, the meeting is adjourned and rescheduled within 7 to 14 days. The rescheduled meeting can proceed regardless of attendance if proper notice was provided. though critical decisions on budgets and major policies still require minimum attendance even in adjourned sessions. How are meeting minutes documented and shared? A designated secretary records minutes during each meeting. Draft minutes circulate to members within 7 days for a 5-day review period. Final approved minutes are distributed within 21 days of the meeting and officially filed. These minutes become public records after formal approval at the subsequent meeting. Common questions about meeting procedures. Meeting procedures permit member substitutions with chairperson approval. Decisions are primarily determined through voting, with the chairperson casting the deciding vote in ties and non-official members receive travel compensation and daily allowances. Additional protocols govern meeting documentation, agenda modifications, and participation requirements. Can someone else attend a meeting in my place? Yes. If you are unable to attend, you may designate a representative from your organization as your substitute. This substitute must receive prior approval from the chairperson. Once approved, your substitute will exercise the same rights and powers you would have had at the meeting. Whenever possible, substitution requests should be submitted in writing at least 3 days before the scheduled meeting. How are decisions made during meetings? Decisions are primarily made through voting, with the majority option prevailing. In the event of a tie, the chairperson exercises a casting vote to resolve the deadlock. In certain circumstances, decisions may be made without convening a meeting by circulating relevant documents and obtaining written opinions from members. All decisions must be meticulously recorded in the official minutes and formally ratified at the subsequent meeting. What payments do non-official members receive for attending? Non-official trustees or members are entitled to claim travel expenses and daily allowances. These reimbursements are calculated at rates equivalent to those provided to central government officers at level 12 in the pay matrix. Members of Parliament and ministers operate under separate compensation arrangements. All claims must be submitted using the standard reimbursement form within 30 days following the meeting. How are meeting minutes recorded and distributed? The secretary or designated officer is responsible for documenting all meeting proceedings. Draft minutes are distributed to all members within 15 days of the meeting's conclusion. Members have a 7-day window to propose corrections before the minutes are finalized. The approved minutes are maintained as permanent records and serve as the official documentation of all decisions reached. Can the meeting agenda be modified? Yes, agenda modifications are permitted with the chairperson's approval. Members wishing to add agenda items should submit their requests at least 7 days prior to the scheduled meeting. For matters of urgency, the chairperson may authorize last-minute additions under the any other business category, provided the majority of members present consent to the inclusion. Reconstitution of Social Security bodies. Frequently asked questions when Social Security bodies are superseded. The government appoints new trustees, manages the transition period, and establishes temporary arrangements until permanent reconstitution occurs. What happens after a Social Security body is superseded? Following supersession, the government appoints new trustees or members in accordance with the provisions outlined in the code. These appointments ensure continuity of governance. Who selects the new trustees or members? The appropriate government authority oversees this selection process. They may directly appoint qualified individuals or facilitate elections as prescribed by the code's procedural guidelines. Who manages operations during the transition period? The government implements temporary administrative arrangements to maintain operational continuity. They designate authorized personnel to exercise the powers and fulfill the duties of the superseded body. How long do these interim arrangements last? Interim arrangements remain in effect for a predetermined duration. The government explicitly defines this time frame when establishing the temporary governance structure. Will the original trustees be able to return to their positions? Reinstatement possibilities depend on the specific circumstances that led to supersession. The government may restore certain original trustees if appropriate, or establish entirely new governance. Each case undergoes evaluation based on the particular factors that necessitated the supersession. How does a Social Security body resume normal operations? Upon conclusion of the transition period, the newly constituted body assumes complete operational control. This encompasses all financial responsibilities, administrative functions, and service delivery obligations as mandated by the code. Are there any reporting requirements during reconstitution? Yes. The interim administration must maintain comprehensive documentation of all activities and decisions made throughout the transition period. These records must be accessible to incoming trustees upon reconstitution and may be subject to government audit and review. Frequently asked questions. Employees' Provident Fund appeals. The EPF appeal process involves submitting Form I to the tribunal. verification by the registrar, scheduled hearings with proper notification, and written decisions delivered to all parties. How do I file an appeal to the tribunal? Submit your appeal using Form I in triplicate with the required fee. You may file it personally, through an authorized agent or lawyer, or via registered post to the registrar. Ensure your appeal follows the specified format and includes all necessary documents. All supporting evidence should be properly indexed and authenticated to facilitate efficient processing. What happens after I submit my appeal? The registrar will timestamp your appeal and verify its completeness. If everything is in order, your appeal will be registered with a serial number. For any deficiencies, you may be granted time to rectify them. The registrar may request additional information or documentation if necessary. Once registered, your appeal becomes part of the official record and advances to the next processing stage. How will I know when my hearing is scheduled? The tribunal will send a written notice regarding the date and venue of your hearing at least 14 days in advance. Cases are scheduled according to a calendar system, with the tribunal aiming to resolve all appeals within 1 year. When feasible, hearings are conducted on consecutive days. It is your responsibility to maintain current contact information with the tribunal. How are final decisions made and communicated? All decisions are documented in writing and signed by the presiding officer. Judgments are pronounced in open court, and copies are provided to all parties free of charge. Additional document copies are available for a prescribed fee. Each written judgment comprehensively details the case facts, arguments presented, legal reasoning, and the final order. The tribunal endeavors to deliver clear, well-reasoned judgments that fully explain the decision basis. What if I need to postpone my hearing date? For postponement requests, submit a written application to the tribunal promptly, clearly stating the valid grounds for your request. The application should be filed as early as possible before the scheduled hearing date. The tribunal has discretionary authority to approve or deny such requests based on the circumstances and may impose certain conditions when granting postponements. Can I represent myself or do I need a lawyer? You have the option to represent yourself or appoint a legal practitioner or authorized representative. If choosing representation, you must provide formal written authorization. While legal representation is not mandatory, it may prove advantageous for complex cases or matters involving contested legal interpretations. What if I disagree with the tribunal's decision? If dissatisfied with the tribunal's ruling, you may appeal to a higher authority within the stipulated time frame, typically 60 days from receipt of the order. Such appeals must be founded on specific points of law rather than general disagreement with the findings. Consulting legal counsel is advisable to determine if your case presents valid grounds for further appeal. Employees State Insurance Corporation Administration, FAQs. The ESI Corporation is led by a Director General, CEO, and Financial Commissioner who receive compensation equivalent to government officials while overseeing operations and finances respectively. Both are appointed by the central government to ensure effective administration of the scheme. Who heads the Employees State Insurance Corporation? The Director General serves as the Chief Executive Officer of the corporation, overseeing all operational aspects of the ESI scheme. The Financial Commissioner manages all financial matters. Both officials are appointed by the central government and report to the corporation's governing body. What pay and benefits do these officials receive? These officials receive compensation packages equivalent to central government officers in similar positions. Officials previously employed by the corporation retain their pension and other benefits. Their compensation is periodically revised in alignment with central government pay commission recommendations and may include official accommodation, vehicle facilities, and other standard government benefits. What are the main duties of the Director General? The Director General conducts meetings, implements decisions, executes contracts, submits required reports, and manages organizational operations. Additionally, the Director General develops strategic plans, implements policies, coordinates with state governments, and represents the corporation in external forums to ensure effective delivery of ESI services nationwide. What does the Financial Commissioner do? Maintains accounts and ensures financial compliance across the organization, prepares comprehensive budgets and monitors expenditure for all schemes, coordinates audits and implements robust financial control systems, evaluates investment opportunities and develops sustainable financial strategies, oversees the disbursement of benefits and management of the ESI fund, ensures financial governance and transparency in all transactions, liaises with external financial institutions and government agencies, performs specialized financial duties as directed by the governing body. How is the broader ESI Corporation structured? The ESI Corporation operates through a hierarchical structure extending beyond the Director General and Financial Commissioner. Regional directors lead state-level operations, while medical commissioners and departmental heads oversee specific functions including benefits administration, medical services, and regulatory compliance. What role does the Standing Committee play in administration? The Standing Committee functions as an executive body that supports administration and policy implementation. It evaluates operational matters, addresses administrative challenges, and provides recommendations to the corporation. The Director General collaborates closely with this committee to ensure the scheme operates efficiently. ESI Fund Investment and Expenditure FAQs. The ESI Corporation follows strict government guidelines for investments, requires appropriate approvals for modifying investment portfolios, and may allocate up to 1,000 crore rupees annually for comprehensive welfare programs. How does ESI Corporation invest its funds? The corporation invests strictly according to central government guidelines. We maintain detailed accounts of all investments and attribute any expenses or losses directly to the fund. Our investment strategy prioritizes security, liquidity, and optimal returns. The investment portfolio undergoes regular review to ensure alignment with both immediate operational requirements and long-term financial sustainability objectives. Can ESI Corporation change its investments? Yes, the corporation has the authority to modify, exchange, or liquidate investments when necessary. However, for transactions that may result in financial loss, prior approval from the central government is mandatory. We follow a rigorous approval process involving assessment by financial experts and comprehensive documentation of all investment decisions. Regular independent audits ensure complete transparency in investment modifications. How much can ESI spend on welfare programs? The corporation can allocate up to 1,000 crore rupees annually for health promotion, welfare activities, rehabilitation services, and employment assistance for insured persons. This ceiling may be adjusted by the central government when circumstances warrant. Budget allocation across various programs is determined through systematic priority assessments and beneficiary needs analysis. Each program undergoes thorough performance evaluation to ensure effective fund utilization. Who oversees the investment decisions of ESI Corporation? A specialized investment committee comprising financial experts, government representatives, and senior exec officials provides oversight for all investment decisions. This committee convenes quarterly to evaluate investment performance, assess market conditions, and formulate strategic recommendations. All deliberations and decisions are meticulously documented and reported to the Standing Committee. What types of investments does ESI Corporation typically make? The corporation predominantly invests in government securities, fixed deposits with nationalized banks, and other low-risk financial instruments as prescribed by government guidelines. All investments must satisfy stringent safety and return criteria. The portfolio maintains appropriate diversification to balance risk factors while ensuring sufficient liquidity for operational requirements. How are ESI funds protected against market fluctuations? The corporation employs conservative investment approach with capital preservation as the primary objective. We maintain adequate reserve funds to mitigate market volatility, while our investment guidelines strictly limit exposure to high-risk assets. Additionally, all investment decisions are informed by comprehensive risk assessments conducted by financial experts, supplemented by regular stress testing of the entire portfolio. ESI Corporation manages property acquisition and disposal through the Director General, with significant transactions requiring Standing Committee approval. Similar approval processes govern contracts based on monetary thresholds. These robust procedures ensure transparency, accountability, and compliance in all property and contractual matters. ESI Property and Contracts. How does ESI acquire property? The Director General is authorized to purchase both movable and immovable property for ESI operational purposes. Standing Committee approval is mandatory for special transactions including property exchanges, long-term leases, or conditional gifts. All acquisitions must adhere to government-prescribed procedures for proper valuation and comprehensive due diligence. The corporation maintains a detailed property register that documents all assets and their current status. Environmental and legal assessments are required before acquiring any immovable property. When can ESI dispose of property? The Director General can independently authorize the sale of movable property. valued up to 1 crore rupees, or grant short-term leases for immovable property. Standing committee approval is required for all other types of property disposal. Transparent auction processes must be utilized for all property disposals unless specifically exempted by guidelines. Every disposal must be properly documented with justification and verification of market value compensation. Comprehensive annual disposal reports must be submitted to the central government documenting all transactions. Who can sign contracts for ESI? The Director General or their authorized representatives may execute contracts on behalf of the corporation. Contracts exceeding 15 crore rupees require prior standing committee approval. The official seal of the corporation must be affixed to contracts valued over 5 lakh rupees. All contracts undergo mandatory legal review before execution to ensure regulatory compliance. A centralized contract management system monitors obligations and timelines for all agreements. Regular audits verify contract fulfillment and identify any deviations from agreed terms. What are the internal control mechanisms for property and contracts? An established internal audit committee provides oversight for all high-value transactions. Quarterly performance reports on property utilization and contract implementation are submitted to the standing committee. A dedicated compliance officer ensures strict adherence to all statutory requirements related to property and contracts. Mandatory conflict of interest declarations are required from all officials involved in property transactions or contract negotiations. Period. ESI Corporation can secure loans with standing committee and central government approval from either the government or financial institutions. Such loans may require property collateral and must adhere to specified repayment schedules, with mandatory annual reporting of all loan activities.
EC loans and financing. FAQs. How can EC Corporation obtain loans? The corporation may secure loans after the standing committee passes a resolution and receives central government approval. Loans can finance land acquisition, building construction, debt refinancing, or other authorized purposes. The standing committee must clearly specify the loan amount, intended purpose, and repayment terms in their resolution. For urgent situations, an expedited approval process may be implemented with special authorization. All loan applications must include a comprehensive financial impact assessment and benefits analysis. What are EC Corporation's borrowing sources? Loans may be obtained from either the central government or authorized financial institutions. When borrowing from banks, the corporation may need to pledge assets as collateral. The corporation can access special financing programs offered by public sector banks with preferential interest rates. International financing options require additional clearance from the Ministry of Finance. The corporation must evaluate and compare terms from multiple lenders before finalizing any loan agreement. What governs EC Corporation's loan repayment? The corporation must service interest and principal according to the stipulated loan agreement. If surplus funds become available, the corporation may accelerate loan repayment ahead of schedule. A dedicated repayment fund is maintained to ensure timely fulfillment of all loan obligations. Any modifications to the repayment schedule require the Director General's approval. Loan restructuring necessitates both standing committee and central government authorization. What loan reporting requirements must EC fulfill? The corporation must submit an annual statement to the central government by the 30th of April. This report must document all loans acquired and repayments executed during the preceding fiscal year. Quarterly interim reports must be furnished to the standing committee for review. The annual audit must incorporate a dedicated section on loan management and compliance. Any payment default or delay must be promptly reported to both the standing committee and central government along with a comprehensive remediation plan. Employee registration under EC. Common questions. EC registration requires employers to enter employee information through the online portal, after which Aadhaar-linked identity cards are issued. Registration numbers serve as unique identifiers that facilitate contribution payments and enable access to comprehensive benefits for employees and their families. How do employers register new employees? employers must enter the employee's full name and Aadhaar number on the official EC portal. The system generates a unique registration number immediately upon submission. This provisional registration number remains valid for 10 days. Within this 10-day window, employers must complete the registration by providing all additional required information. Required information includes accurate date of birth, current contact details, comprehensive family member information, and complete employment particulars. The employer is responsible for verifying all information for accuracy before final submission to ensure proper benefit eligibility. What kind of identity cards are issued? The EC Corporation issues secure Aadhaar-linked identity cards to all registered individuals. These identification cards are provided to both the insured employee and their eligible family members. Cards may be issued in either electronic, digital format or as physical cards, depending on regional implementation. Digital cards can be conveniently accessed and displayed through the official EC mobile application. Physical cards are delivered directly to the registered residential address of the employee. These identity cards must be presented when accessing EC medical facilities and when claiming any benefits under the scheme. What is the registration number used for? The EC registration number serves two primary purposes within the system. Employers utilize this number to process contribution payments and complete all other EC-related administrative tasks. Employees use this identification number to access medical services and other entitled benefits for themselves and their registered family members. The number functions as a permanent unique identifier throughout the employee's entire EC coverage period. It must be quoted in all correspondence and interactions with the EC Corporation to ensure proper record matching. The number enables accurate tracking of contribution history and benefit eligibility throughout employment. When should employees be registered under EC? Employees must be registered under EC from their very first day of employment at any covered establishment. The complete registration process should be initiated and finalized within 10 days of an employee joining the organization. Delayed or incomplete registration may result in significant penalties and legal consequences for the employer. Employers cannot defer EC registration during any probationary period, training phase, or temporary assignment. All eligible temporary and contract employees must also be registered if they meet the applicable wage criteria for EC coverage. Proper and timely registration ensures employees can access comprehensive medical benefits without unnecessary delays and helps employers maintain full compliance with all EC regulatory requirements. Accurate registration information also streamlines the claims process and improves overall service delivery within the EC ecosystem. Common questions about EC contributions. EC contributions are divided between employers, 3.25%, and employees, 0.75%, with special exemptions for employees with disabilities. These contributions fund essential social security benefits including healthcare, maternity support, disability assistance, and dependent care. How much does an employer need to contribute to EC? Employers contribute 3.25% of each employee's wages toward EC. This amount is always rounded up to the nearest rupee. For instance, if an employee earns 10,000, the employer's contribution would be 325. This mandatory contribution applies to all eligible establishments and must be remitted by the deadline to avoid financial penalties. How much does an employee need to contribute to EC? Employees contribute a smaller portion of 0.75% of their wages. Like the employer's share, this amount is rounded up to the nearest rupee. For an employee with a monthly salary of 10,000, their contribution would be 75. The employer deducts this amount directly from the employee's monthly wages. Together, the combined contribution rate of 4%, 3.25% plus 0.75%, ensures comprehensive social security coverage. Are there any special rules for employees with disabilities? Yes. Employers are exempt from paying their share of contributions for employees with disabilities for up to 3 years. During this period, the central government covers the employer's contribution to the EC Corporation. This provision serves as an incentive to promote employment opportunities for persons with disabilities. To qualify for this benefit, employers must maintain proper documentation verifying the employee's disability status. When and how are EC contributions paid? Monthly contributions must be remitted by the 15th day of the following month. Payments are processed through the EC online portal using various electronic payment methods. Employers bear the responsibility of both collecting the employee's portion and adding their own contribution. Failure to meet payment deadlines results in interest charges and potential penalties as stipulated under the code. What happens if contributions are not paid on time? Late contributions incur interest at a rate of 12% per annum. Consistent non-payment may trigger recovery proceedings similar to those for land revenue arrears. The EC Corporation reserves the right to pursue legal action against employers who default. While employees remain eligible for benefits during periods of non-payment, they may encounter difficulties when attempting to claim them. All contributions serve to provide vital medical benefits and social security protections to workers and their families. The EC Fund ensures employees have access to quality health care, sickness benefits, maternity support, and disability assistance when needed, establishing a robust safety net for India's workforce. FAQs. EC Administrative Expenses. The EC scheme maintains strict oversight of administrative expenses through a 15% spending cap, ensuring that the majority of funds directly benefit members rather than supporting operational infrastructure. What counts as EC administrative expenses? Administrative expenses encompass committee members' fees, staff salaries, office maintenance, equipment depreciation, membership fees, audit costs, legal expenses, and operational overheads. These expenditures maintain the essential infrastructure of the EC system. Specific examples include office rent, utility bills, IT systems, staff training programs, and technological infrastructure. Both routine expenditures like office supplies and capital investments such as facility renovations fall under this category. Is there a limit on how much can be spent on administration? Yes, a statutory limit exists. Administrative expenses are capped at 15% of the EC's total annual income. This regulation ensures that the majority of funds are directed toward beneficiary services rather than operational costs. Compliance with this threshold is verified through rigorous financial audits and transparent annual reporting. Proactive cost control measures are implemented when expenditures approach the permitted maximum. What exactly is the EC scheme? The EC scheme comprises the comprehensive framework of rules, regulations, notifications, and administrative directives established by the corporation to implement the code's provisions. It serves as the operational blueprint for the entire social security system. The scheme delivers essential social security and health insurance coverage to employees within the organized sector. Established under the EC Act of 1948, it operates under the management of the Employees State Insurance Corporation, ESIC. How are administrative expenses budgeted and approved? The EC Corporation develops a detailed annual budget with specific allocations for various administrative expense categories. This budget requires formal approval from both the Standing Committee and the corporation's governing body. Quarterly financial assessments ensure expenditures remain within authorized parameters. Significant deviations from budgeted amounts necessitate special authorization supported by comprehensive justification. Who oversees administrative spending compliance? Primary responsibility for monitoring administrative expenditures rests with the Financial Commissioner of the EC Corporation. Internal audit teams conduct systematic expenditure reviews across all regional offices. The Controller and Auditor General (CAG) performs independent verification through regular audits. Detailed administrative expenditure reports are published annually to ensure transparency and maintain public accountability. Sickness benefit. Common question: sickness benefits provide financial support during illness, covering 70–80% of your standard wage rate for periods ranging from 91 to 730 days, depending on your medical condition and contribution history. Who can get sickness benefits? You qualify if you've contributed for at least 78 days in the relevant contribution period. For newly covered employees, this requirement applies to the first 2 completed contribution periods. Special provisions exist for women on maternity leave and those already receiving temporary disability benefits. Your medical certificate must come from an authorized EC dispensary or hospital practitioner. How much money will I receive? Standard sickness benefit is 70% of your daily wage rate. For certain serious illnesses, You may receive enhanced benefits at 80% of your rate for up to 730 days. Benefits are calculated based on your average daily wages during a specified period. Payments are deposited directly to your bank account and are tax-free under the Income Tax Act. When do benefits start? A 2-day waiting period applies before benefits begin, unless your sickness continues without interruption. This waiting period is waived if you're hospitalized. Submit your claim within 3 days of receiving your sickness certification. Late submissions may be considered with proper justification. How long can I receive benefits? Regular sickness benefits extend up to 91 days across any 2 consecutive benefit periods. For specific long-term conditions like tuberculosis, leprosy, mental disorders, malignancies, or other chronic illnesses specified by EC, benefits may continue for up to 730 days. Periodic medical board examinations are required to continue receiving extended benefits. What documentation do I need to provide? Medical certificate from an authorized EC doctor or approved practitioner, your EC identity card or pension card, bank account details for direct benefit transfer completed, and signed claim form. Can I work while receiving sickness benefits? No, you cannot work or earn wages on days you receive sickness benefits. Doing so may lead to disqualification and recovery of benefits paid during that period. You must properly notify your employer about your sickness absence. What happens if my illness becomes permanent? If your condition results in permanent disability, you may be assessed for permanent disablement benefits. A medical board will evaluate the extent of your disability and determine your eligibility and benefit amount. This assessment replaces the sickness benefit with appropriate long-term support. Frequently asked questions. Maternity benefits. Maternity benefits provide comprehensive financial support during pregnancy and childcare periods. To qualify, you must have contributed for at least 70 days in the previous 2 payment periods. These benefits match your regular daily wage and can extend from 12 to 26 weeks depending on your circumstances. In areas without EC medical facilities, you may also receive additional medical bonuses. How do I qualify for maternity benefits? You must have contributed to the scheme for at least 70 days within the last 2 payment periods. For most women, benefits extend up to 26 weeks, with the option to claim up to 8 weeks before your expected delivery date. If you already have 2 or more children, your benefit period is reduced to 12 weeks. Your employment status must be active when submitting your claim. You are required to notify your employer in writing about your anticipated absence period. What provisions exist for adoption or pregnancy complications? Adoptive mothers or those using surrogacy arrangements are eligible for 12 weeks of benefits. In cases of miscarriage or medical termination, you can receive benefits for 6 weeks. Additional leave is granted for pregnancy-related illnesses or complications. Special provisions with extended recovery time are available for stillbirth or premature delivery cases. All complication-related claims must be supported by documentation from a registered medical practitioner. What is the benefit amount I will receive? Your benefit amount equals your average daily wage during the qualifying period. An additional medical bonus of 7,500 rupees is provided if EC medical facilities are unavailable in your area. This medical bonus is limited to your first 2 pregnancies only. Benefits are typically disbursed as a lump sum advance payment covering the entire eligible period. All maternity benefits are exempt from taxation under current income tax regulations. What is the application process for maternity benefits? Complete and submit Form 19 along with all required documentation to your employer. Include a medical certificate confirming your pregnancy status and expected delivery date. You may submit your application up to 50 days before your expected delivery date. For complication-related claims or post-delivery applications, submit within 30 days of the occurrence. What additional support measures are available during maternity? You are entitled to 2 daily nursing breaks until your child reaches 15 months of age. Your employment position remains protected throughout your maternity leave period. Many employers offer additional accommodations such as flexible work arrangements upon your return. Legal protections prevent dismissal during maternity leave or due to pregnancy-related reasons. Workplaces with 50 or more employees may provide access to child care facilities or creches. Disablement and dependence benefits. Frequently asked questions. Workers injured on the job receive 90% of their wages as temporary or permanent disability benefits. For permanent disabilities, payment duration depends on injury severity. When a worker dies from work-related injuries, dependents receive benefits with specific allocations. Widow, 3/5, children 2/5, and other eligible family members according to established guidelines. What are temporary disablement benefits? These benefits provide 90% of your standard daily wage when you're unable to work for more than 3 days due to a work-related injury. Benefits commence from the 4th day of disability. However, if your disability extends beyond 24 days, payments will be retroactively applied from the 1st day of incapacity. How do permanent disablement benefits work? If your work injury results in permanent disability, you'll receive 90% of your standard daily wage, adjusted according to your disability percentage. A medical board will assess your condition to determine whether benefits will be provided for a fixed period or for life. The severity of your disability directly influences the final benefit amount. Who can receive dependents benefits after a worker's death? Following a worker's death from work-related injuries, their family receives financial support. The widow receives 3/5 of the full benefit rate, while children, including legally adopted, receive 2/5 until they reach age 25. If the worker's mother is widowed, she qualifies for 2/5 of the full rate. These provisions ensure continued financial security for the worker's family. What if there are no immediate family members? In the absence of a widow, children, or widowed mother, other dependent family members may qualify for benefits. These can include dependent parents, unmarried sisters, minor brothers, and widowed daughters-in-law who were substantially dependent on the deceased worker at the time of death. Benefit amounts vary based on relationship to the worker. How do I apply for disablement benefits? To claim disablement benefits, submit Form 12 with comprehensive medical documentation. Your employer must report the work-related accident using Form 16 within 24 hours of the incident. The local office will review your application and medical evidence before making an eligibility determination. Is there a time limit for claiming these benefits? Claims for disablement benefits must be filed within 1 year of the accident date. For dependents benefits, claims should be submitted within 1 year of the worker's death. The authority may consider late claims if there is reasonable justification for the delay in application. Are there any rehabilitation benefits available? Beyond cash benefits, the scheme offers comprehensive rehabilitation support. Medical rehabilitation includes specialized treatment programs, while vocational rehabilitation helps disabled workers develop new suitable skills through training programs, assistive devices, and job placement services to facilitate workforce reintegration. How are these benefits affected by other income? Disablement and dependence benefits function independently of any other income sources. These entitlements are based solely on the worker's contributions and the nature of the work-related injury or death. Recipients may continue receiving these benefits regardless of additional employment income or pension benefits they might acquire. Medical benefit eligibility. Frequently asked questions. EC medical benefits are available to insured persons who meet minimum contribution requirements and their eligible family members. Eligibility criteria vary based on contribution history, with special provisions for new enrollees, retirees, and those with specific medical conditions. Benefits encompass a comprehensive range of healthcare services including outpatient care, hospitalization, specialized treatments, and emergency medical services. How do I qualify for medical benefits? You qualify when you make regular contributions through your employer. Eligibility also extends to periods when you are receiving sickness benefits, maternity benefits, or disablement benefits due to work-related injuries. Your coverage begins from the date of your first contribution and continues as long as you fulfill the minimum contribution requirements established by the scheme. I am newly enrolled in the scheme. When can I access medical benefits? As a new member, you receive immediate medical coverage for your first 3 months following registration, regardless of your contribution history. If your employment continues for 3 months or longer with ongoing contributions, your benefits continue seamlessly until the next benefit period commences. This provision ensures uninterrupted healthcare access during your initial employment phase. What is the minimum contribution requirement? You must contribute for at least 78 days within a 6-month contribution period to receive full medical benefits until the end of the corresponding benefit period. If you've contributed for 39 to 77 days, you may receive reduced benefits or be required to pay a nominal share of your healthcare expenses. With fewer than 39 contribution days, you may need to submit a formal application for benefit extension with appropriate justification. Are my family members eligible for medical benefits? Yes. Your family members receive medical coverage from the date specified in your policy. Their eligibility continues throughout your benefit period. Covered family members include your spouse, dependent children under 25 years of age, and dependent parents who meet the specified income criteria. In the event of your death, they remain covered until the date your coverage would have expired for that benefit period. How does changing employment affect my medical benefits? If you transition to another employer covered under the EC scheme, your benefits continue without interruption, provided you maintain the required contribution levels. There may be a brief administrative period while your records transfer to your new employer, but your coverage remains valid. It is essential to ensure your new employer registers you under the scheme within 10 days of your joining date. How can I access medical services when traveling outside my local area? You can utilize emergency medical services at any EC hospital or dispensary nationwide by presenting your valid EC identity card. For scheduled or non-emergency treatments, you may need to obtain a referral from your local EC medical officer. The scheme provides reimbursement for medical expenses incurred in areas without EC facilities, subject to specific conditions and predetermined financial limits. What medical benefits are available after retirement? Post-retirement, you may continue receiving medical benefits under certain conditions. If you have contributed for a minimum of 5 years prior to reaching superannuation age, you and your spouse can receive lifelong medical coverage through the Retired Insured Person Medical Benefit Scheme by making a one-time contribution. This ensures healthcare security throughout your retirement years. EC Society structure. Frequently asked questions. The EC Society operates through a 4-tier governance structure. The governing body serves as the highest authority, supported by the Executive Committee, with coordination by the Director of EC Services, and day-to-day administration by the Secretariat. This structure ensures effective policy making, implementation, and service delivery. What is the highest authority in the EC Society? The governing body is the highest authority, headed by the State Chief Secretary. It comprises 15-20 members including representatives from health, labor, and finance departments, as well as employer and employee representatives. This body meets twice yearly to review policy implementation and approve major financial decisions. Who manages the regular operations of the EC Society? The Executive Committee, chaired by the Additional Chief Secretary of EC, manages regular operations. With 8-10 members from various departments and stakeholder groups, this committee meets quarterly to monitor performance, address operational challenges, and ensure compliance with governing body directives. They also oversee budgetary allocations and expenditure. Who coordinates between the committees? The Director of EC Services acts as both Chief Executive Officer and Member Secretary of the Governing Body and Executive Committee. This role ensures seamless coordination between policy decisions and implementation by preparing agendas, documenting proceedings, and following up on action items. The Director maintains communication flow between tiers and translates strategic decisions into operational actions. How is the day-to-day administration handled? The Secretariat manages daily operations of all society activities, led by the Director and supported by administrative, technical, and financial staff. They handle correspondence, maintain records, process claims, and coordinate with healthcare providers. The Secretariat also addresses beneficiary grievances and ensures timely service delivery. How are funds managed within the EC Society structure? The finance wing of the Secretariat manages financial operations under Executive Committee guidance. They handle contribution collections, fund investments, benefit disbursements, and service provider payments. This wing prepares annual budgets, maintains accounts, and ensures transparency through regular audits and financial reporting to the governing body. What role do regional offices play in the EC structure? Regional offices function as local extensions of the Secretariat. They implement policies locally, coordinate with area healthcare providers, process regional claims, and address local beneficiary concerns. These offices report to the director and ensure EC services are accessible throughout the coverage area while adapting central policies to meet local needs. How does the EC Society ensure stakeholder representation? Stakeholder representation is integrated at multiple levels, with both the governing body and executive committee including members from employer associations, trade unions, and beneficiary groups. This multi-stakeholder approach ensures policies reflect the perspectives of all affected parties, promoting transparency and accountability in governance. This well-defined four-tier organizational structure, with clear roles and responsibilities at each level, enables the EC Society to effectively deliver comprehensive social security benefits to eligible workers and their families. EC Society governance. Frequently asked questions. EC Society governance operates through structured meetings with established quorum requirements, regularly scheduled committee sessions throughout the year, and comprehensive financial processes including annual auditing and standardized budgeting protocols to ensure maximum transparency and accountability in administration. How are decisions made in EC Society meetings? A quorum of at least 3 members or 1/3 of the total membership must be present for a valid meeting to convene. Decisions require a simple majority vote from attending members. In cases of a tie, the chairman exercises a casting vote to resolve the deadlock, ensuring definitive resolution on all matters. How often do EC committees meet? The governing body convenes biannually, minimum twice per year, to evaluate and authorize major policy initiatives. The executive committee maintains a more frequent quarterly schedule, minimum once every 3 months, to effectively monitor implementation and address operational challenges. This structured meeting calendar ensures consistent governance oversight and prompt decision-making. How does the EC Society manage its financial resources? The Society submits its comprehensive budget proposal by the 10th of December annually for the forthcoming financial year. The Controller and Auditor General of India conducts thorough annual audits to verify compliance with established financial regulations. The financial calendar operates from the 1st of April through the 31st of March, aligning with the standard government fiscal framework. What financial documentation must the EC Society maintain? The Society maintains meticulous financial records including detailed cash books, comprehensive ledgers, complete asset registers, and itemized expenditure statements. Every financial transaction requires proper documentation with corresponding vouchers and receipts. These records undergo rigorous internal audits and external verification by designated regulatory agencies. Can special meetings be convened outside the regular schedule? Yes. The chairman of either the governing body or executive committee possesses the authority to convene extraordinary meetings to address urgent matters requiring immediate attention. While a standard 7-day notice period applies, this requirement may be waived during emergencies. All members must receive advance notification of the meeting agenda. How are meeting proceedings documented and preserved? All governing body and executive committee proceedings are meticulously documented in official minutes. These minutes require formal approval during the subsequent meeting and authentication by the chairman's signature. Once approved, these minutes constitute the authoritative record of all decisions and become binding directives for implementation by the Secretariat. The EC Society's comprehensive governance framework establishes systematic decision-making protocols, ensures robust financial accountability, and maintains transparent administration across all operational functions and institutional responsibilities. Gratuity payment FAQs. Gratuity nominations require proper documentation through Form 3, can be updated whenever necessary, and include special provisions for cases where beneficiaries are minors. What happens when a gratuity beneficiary is a minor? When a nominee or heir is under 18 years old, the entire gratuity amount is invested in a term deposit at the State Bank of India or another nationalized bank. This safeguards the funds for the minor's future benefit. The account is administered by the minor's legal guardian until they reach adulthood, 18 years. All interest accrued during this period is automatically added to the principal amount. How do I submit my gratuity nomination? Complete and submit your nomination using Form 3 and duplicate to your employer. Your employer will verify the information, record it officially, and return one endorsed copy to you as confirmation. Ensure all mandatory fields are accurately completed and the form bears both your signature and those of 2 witnesses. Store your confirmed copy securely as it serves as official proof of your nomination. When should I submit my nomination form? New employees should submit it immediately upon joining. If you've already completed 1 year of service, submit your form without delay. Following significant life events such as marriage or having children, submit a fresh nomination form to include your new family members as beneficiaries. Remember that neglecting to update your nomination could create serious complications for your beneficiaries in claiming their rightful benefits. Can I change my nomination later? Absolutely. You can modify your nomination at any time by submitting a new Form 3 to your employer, following the same procedure as your original nomination. There are no restrictions on how frequently you can update your nomination throughout your employment tenure. Each newly submitted nomination automatically supersedes and invalidates all previous nominations. What if I don't submit a nomination form? In the absence of a nomination form, your gratuity will be distributed to your legal heirs according to applicable succession laws in the event of your death. This alternative process is typically time-consuming and may cause significant delays in payment to your family members. To ensure prompt settlement, it's strongly recommended to maintain a valid, up-to-date nomination. Do I need witnesses for my gratuity nomination? Yes. Your Form 3 nomination requires attestation by 2 witnesses who must sign the form confirming they observed your signature. For transparency and to prevent potential conflicts of interest, witnesses should ideally be your colleagues who are not themselves named as your nominees on the form. Gratuity application and payment. Frequently asked questions. Gratuity payment requires proper form submission, receives employer response within 15 days, is disbursed via bank transfer or demand draft, and provides comprehensive options for dispute resolution through established procedures. How do I apply for gratuity payment? Submit your application using Form IV within 30 days of becoming eligible for gratuity benefits. If you're retiring, you may apply up to 30 days before your final working day to ensure timely processing. If you miss the deadline, you can still apply with a written explanation for the delay, which will be considered on a case-by-case basis. Ensure you include all necessary supporting documents with your application, such as complete service records and valid identification proof. Always retain a copy of your submitted application and all attachments for your personal records. How long will my employer take to respond? Your employer is legally required to respond within 15 days after receiving your completed application. You will receive Form V detailing either the approved amount and expected payment date, or the specific reasons for claim rejection. If you don't receive Form V within the mandated 15-day period, you should immediately contact your HR department for clarification. The calculation must include your basic salary plus dearness allowance for the entire eligibility period as specified under the Payment of Gratuity Act. How will I receive my gratuity payment? Your payment will be disbursed either through a demand draft or direct electronic transfer to your registered bank account. Your employer will notify the appropriate authorities about the completed payment as required by law. The payment remains tax exempt up to the limit prescribed under the Income Tax Act, currently 20 lakhs. Your employer must complete the full payment within 30 days from the date it becomes due. Any payment delay beyond the 30-day period may result in additional interest being applied to your gratuity amount as per statutory provisions. What if my employer refuses to pay or offers an insufficient amount? If you disagree with your employer's decision, you can file a formal complaint with the competent authority using Form 6. This initiates a structured hearing process where an appointed authority will thoroughly review your case before making a determination. Your complaint must be filed within 90 days from the date when the gratuity became legally payable. Both parties for you and your employer for will have equal opportunity to present evidence and arguments during the hearing proceedings. The competent authority will issue a final decision that is legally binding on all involved parties. Am I eligible for gratuity if I resign? Yes, you remain eligible for gratuity benefits if you've completed at least 5 years of continuous service with the organization. The only exclusions apply if your employment was terminated due to proven serious misconduct as defined under the Act. Even in cases of voluntary resignation, your gratuity entitlement remains intact after the minimum 5-year service requirement. How is my gratuity amount calculated? The standard formula is last drawn salary divide 26, 15 number of completed years of service. For calculation purposes, salary specifically refers to basic salary plus dearness allowance only. Any service period exceeding 6 months is rounded up and counted as a full year in the final calculation. There is no statutory upper limit on the gratuity amount payable under the Act, though tax exemption limits may apply. Common questions about maternity benefits. Maternity benefits include medical certification requirements, payment procedures within 48 hours of documentation submission, nursing breaks for mothers, and nominee provisions in case of death. Documentation requirements. What documents do I need for my pregnancy or childbirth? You need a medical certificate, Form X, from a registered medical practitioner confirming your pregnancy, delivery, miscarriage, or medical termination. The certificate must include details about your condition and expected or actual delivery date. In cases where medical certificates are unavailable, entries from official birth or death registers may be accepted as alternative proof. How far in advance should I notify my employer? Notify your employer at least 8 weeks before your expected delivery date to allow sufficient time for arranging temporary coverage and preparing for your absence. Payment procedures. How do I claim my maternity benefits? Submit a written notice using Form 11 to your employer detailing your planned absence period and expected return date. Your employer must pay you within 48 hours after you submit your completed medical certificate. Medical bonus payments, if eligible, will be included with your second payment installment. How soon will I receive my payment? Payment must be processed and disbursed within 48 hours after submitting your properly completed medical certificate. You have the right to file a complaint with local labor authorities if you experience delays. How are maternity benefit amounts calculated? Benefits are calculated based on your average daily wage for your actual absence period, including pre-delivery rest, delivery day, and post-delivery recovery, up to the maximum weeks specified by law. Nursing and childcare. Am I allowed breaks for nursing my baby? Yes. You're entitled to 2 15-minute breaks during working hours daily for nursing your child until they reach 15 months of age. You also receive 15 additional minutes for travel between your workplace and the designated child care area, depending on distance. Can these nursing breaks be combined with regular breaks? With employer permission, nursing breaks may be combined with regular rest periods if this better accommodates your baby's feeding schedule, provided the total break duration remains unchanged. Special circumstances. Who receives my benefits if something happens to me? In the event of your passing, outstanding maternity benefits will be paid to your officially designated nominee in your employment records. Keep this nomination updated after major life changes such as marriage or childbirth. What if I experience a miscarriage or medical termination? You remain entitled to maternity benefits for 6 weeks immediately following a miscarriage or medical termination. Submit a medical certificate confirming the events to claim these benefits. Are there special provisions for women with medical complications? Yes. Pregnancy-related illnesses or complications may entitle you to additional paid leave of up to 1 month, separate from regular maternity leave, with proper documentation from your healthcare provider. Returning to work. Can my employer change my position during my maternity leave? Your employer cannot terminate your employment during maternity leave. Upon return, you should be reinstated to the same or equivalent position with identical pay and benefits as before your leave. What if I need to extend my leave due to medical reasons? For medically necessary extensions, submit a new medical certificate explaining your situation. While extended leave beyond the statutory period may be unpaid, your position remains protected for a reasonable period as determined by company policy and applicable laws. Frequently asked questions. Creche facilities. Organizations with 50+ women employees must provide well-maintained childcare facilities for children under 6 years of age, accessible to all employees regardless of gender. These facilities enable working parents to balance professional and family responsibilities while ensuring their children receive proper care. When must a company provide a child care facility? Any establishment employing 50 or more women must establish and maintain a child care facility, creche, for children under 6 years old. This is a mandatory legal requirement, not a discretionary benefit. The facility must remain operational throughout all working hours, including shift periods. Organizations must implement this provision within 6 months of reaching the 50 women employees threshold. What facilities should the child care center provide? The child care space must be adequately sized, providing a minimum of 10 square feet per child. Proper ventilation, sufficient lighting, and hygienic sanitation facilities are essential. The center must be staffed by qualified women with appropriate child care expertise. Age-appropriate educational materials, toys, and safe recreational equipment must be available. Potable drinking water, proper food storage, and meal preparation areas must be maintained. Comprehensive first aid supplies and clearly documented emergency protocols are mandatory. Where should the child care facility be located? The child care facility should be situated within the company premises or in immediate proximity. It must be easily accessible to all women employees, including those with flexible working arrangements. The facility should be established in a secure, quiet environment away from production areas and high traffic zones. Ground floor locations are recommended to facilitate rapid evacuation during emergencies. Can male employees use a child care facility? Yes. While the regulatory requirement is based on the number of women employees, the child care facility is typically accessible to all employees with children under 6, regardless of gender. Male and female employees have equal entitlements to utilize the facility for their children. Organizations should implement transparent, non-discriminatory policies regarding facility usage. What staff qualifications are required for the creche? The facility must maintain a minimum ratio of 1 trained child care professional for every 10 children. Staff must possess relevant child care credentials or qualifications in early childhood education. All personnel must undergo comprehensive background verification and health assessments. At least one staff member certified in pediatric first aid must be present at all times. How should companies maintain health and safety standards? Systematic cleaning and disinfection of all surfaces, toys, and equipment is required. Appropriate child-to-caregiver ratios must be consistently maintained. Stringent check-in and check-out procedures must be implemented to safeguard children. Documented quarterly safety inspections must be conducted. Nutritionally balanced meals and snacks must be provided, with careful attention to food allergies and specific dietary requirements. Maternity benefit FAQs. Employees are legally protected from dismissal during pregnancy and maternity leave periods. Maternity benefits may only be forfeited in cases of documented serious misconduct. Employees have clear pathways for appeals and complaints if benefits are improperly denied. Can I lose my job during pregnancy or maternity leave? No. Your employer is legally prohibited from terminating your employment or altering your position in a detrimental manner during pregnancy or while on maternity leave. Additionally, they cannot issue a termination notice that would become effective during your protected maternity period. Are there any situations where I could lose my maternity benefits? Yes, but only in cases of serious misconduct. Maternity benefits may be forfeited if you deliberately damage company property, commit physical assault, engage in criminal activity, misappropriate company resources, provide false information on critical matters, or deliberately violate established safety protocols. These actions constitute serious misconduct under employment regulations. What can I do if I'm unfairly denied my maternity benefits? You have 2 official recourse options. 1. Submit a formal appeal using Form 13 within 60 days to the appropriate governing authority. Their determination will be binding and final. 2. If you have evidence that your benefits are being wrongfully withheld, you may file an official complaint using Form 12 to the designated labor inspector who oversees maternity benefit compliance. How much maternity leave am I entitled to? Qualified women employees are entitled to 26 weeks of fully paid maternity leave. However, if you already have 2 or more children, your entitlement is reduced to 12 weeks. You have the flexibility to commence this leave up to 8 weeks before your expected delivery date. Am I eligible for maternity benefits if I'm a contract worker? Yes. Eligibility is determined by your employment duration rather than your employment type. Provided you have completed at least 80 working days with your employer during the 12 months preceding your expected delivery date, you qualify for full maternity benefits regardless of whether you are employed on a permanent or contractual basis. What happens to my benefits if I have a miscarriage or medical termination? In the unfortunate event of a miscarriage or medical termination of pregnancy, you are legally entitled to 6 weeks of paid leave commencing from the date of the miscarriage or termination procedure. This entitlement applies irrespective of the number of children you already have. Are there any additional benefits for adoptive mothers? Yes. Women who legally adopt a child under 3 months of age are entitled to 12 weeks of maternity leave, beginning from the date the child is officially handed over to the adoptive mother. Equivalent benefits are extended to commissioning mothers and surrogacy arrangements to ensure equitable treatment of all maternal situations. Building workers cess collection. FAQs construction projects require cess payments calculated on total project costs. Project details must be submitted within 60 days of commencement, payments must be completed before approval, and government projects utilize different collection procedures through direct bill deductions. The Building and Other Construction Workers Welfare Cess Act mandates this collection to fund welfare initiatives for construction workers. When do I need to submit information about my construction project? You must submit details in Form 15 within 60 days of starting work or paying cess. Update any changes within 30 days. Late submissions may incur penalties under the Act. Required information includes total estimated cost, project duration, and workforce size. How do I calculate how much cess to pay? Calculate payment based on rates from your state's PWD, CPWD, or RERA submissions. Have a chartered engineer verify your calculations. Payment is required in advance. The standard rate is typically 1% of the total construction cost, excluding land. Include all material, labor, equipment, and supervision costs in your calculation. Do I need to pay cess before getting construction approval? Yes. When applying for construction approval, include proof of online cess payment. For projects exceeding 1 year, installment payments are permitted. The first installment must be paid before approval, with subsequent payments following the agreed schedule. Non-payment may result in work stoppage. How are government construction projects handled? For government or SU projects, cess is deducted directly from bills. These funds must be transferred to the State Building Workers Welfare Board within 30 days. Deductions are typically processed by the Accounts Department when processing contractor payments. Government agencies serve as collection intermediaries in these cases. What happens if I don't pay the required cess amount? Non-payment can result in penalties up to twice the cess amount due. Authorities may issue stop work orders until payment completion. Severe non-compliance cases may lead to legal action against the responsible employer or contractor. Are there any exemptions from paying the building workers cess? Exemptions may apply to repair works below certain value thresholds, individual residential construction under specified built-up areas, and select religious or charitable construction projects. However, exemption certificates must be obtained from the appropriate authority before construction begins. How can I verify that my cess payment has been properly credited? After payment online or through designated channels, you'll receive a receipt with a unique transaction number. Verify this payment through the Welfare Board's online portal using your registration details. Maintain all cess payment records for at least 5 years, as these may be required during audits or inspections. Building workers cess assessment. Frequently asked questions. Assessment officers evaluate submissions within 90 days and issue formal orders detailing payment status. They may conduct site inspections to verify construction costs and can request additional documentation if calculations appear inadequate. Employers who have overpaid are eligible for refunds through a structured application process. How does the assessment order work? The assessment officer will thoroughly evaluate your Form 18 submission within 90 days. Following this review, they will issue a comprehensive order detailing the total cess amount due, payments already made, and any outstanding balance. This official assessment order serves as crucial documentation for your financial records and as definitive proof of compliance with your cess obligations. What happens if my cess calculation seems too low? If your calculated payment appears insufficient, the officer will issue a formal notice requesting clarification. You must respond within 30 days with comprehensive supporting documentation to justify your calculation. You may also request an in-person hearing to present your case directly. Inadequate responses may result in a revised assessment with potential penalties and interest charges. Can officers inspect my construction site? Yes. Assessment officers have full authority to conduct on-site inspections and examine all relevant documentation to accurately determine construction costs and verify appropriate cess amounts. These inspections may occur with or without prior notification. You are legally required to provide complete access to all construction areas, financial records, and project documentation during such inspections. How can I get a refund if I've paid too much? If you've overpaid due to work stoppage, early project termination, or significant plan modifications, you can submit a refund request using Form 17. Include comprehensive documentation verifying the changed circumstances that resulted in overpayment. Refund applications are processed within 30 days following the issuance of the final assessment order, with approved amounts transferred directly to your registered account. What information must be included in the assessment order? The assessment order must contain the precise date of assessment, the total cess amount assessed, all payments previously made, any remaining balance due, and the specific deadline for outstanding payments. Additionally, it must include detailed information about the appeals process, including the time frame and procedures for contesting the assessment if you disagree with the determination. How long do I need to keep cess payment records? All documentation related to cess payments must be preserved for a minimum of 3 years from the date of the final entry. This includes assessment orders, payment receipts, all correspondence with assessment authorities, calculation worksheets, and any supporting documentation that validates your cess computations. These records may be requested during compliance audits or inspections. Can I challenge the assessment if I think it's incorrect? Yes. You have the legal right to contest any assessment order you believe is inaccurate. To do so, file a formal appeal with the designated appellate authority within 90 days of receiving the assessment order. Your appeal submission must include comprehensive supporting documentation, specific grounds for objection, and any relevant precedents that substantiate your claim of incorrect assessment. Common questions. Building worker cess. Building worker cess is a mandatory 1% fee on construction costs paid by employers. Payment must occur within 30 days of collection, with 1% monthly interest penalties for late payments. Appeals against assessments must be filed within 90 days. All collected funds support essential worker welfare programs including healthcare, safety initiatives, and educational benefits. What happens if I pay the cess late? Late payments incur interest at 1% per month or part thereof. For example, a 45-day delay results in a 2-month interest charge. Consistent late payments may trigger additional penalties and affect future project approvals. The board maintains payment compliance records that could impact your company's standing with regulatory authorities. How soon must I transfer the collected cess? All collected cess must be transferred to the board's fund within 30 days via the online payment system. The 30-day period begins from each payment milestone completion or client collection date. For ongoing projects, transfers should occur as construction progresses rather than waiting for project completion. Maintain all electronic receipts for audit purposes. What if I disagree with the assessment order? You may file an appeal using Form 19 within 90 days to the appellate authority, including specific documentation and the required fee. Your appeal must clearly state the grounds for disagreement with supporting evidence. You may need to deposit a percentage of the disputed amount during the appeal process. The authority typically renders decisions within 180 days, and legal representation is permitted at hearings. Who is responsible for paying the cess? Employers bear responsibility for cess payment on all construction projects based on total construction cost. This includes principal employers, contractors, and government departments executing construction work. For multi-contractor projects, the primary employer holds ultimate responsibility, though arrangements can be made with subcontractors. Even smaller renovation projects exceeding the minimum threshold require payment. Government projects are not exempt. Responsibilities include accurate calculation, timely payment, and maintaining documentation for at least 5 years. Building workers registration. Frequently asked questions. State governments manage online registration for construction workers who complete 90+ working days annually. Workers receive digital ID cards and can access welfare benefits across states through an Aadhaar-linked portal. This streamlined registration process ensures continuous access to welfare schemes and social security benefits regardless of where workers relocate for employment. Who handles the registration of building workers? State governments and welfare boards are responsible for registering all building workers in their jurisdiction. They maintain an Aadhaar-linked online portal for this purpose. Employers must ensure their workers are properly registered. For workers with limited digital access, local authorities establish facilitation centers to provide hands-on assistance with the registration process. How is the registration process done? The entire registration process is conducted online through a dedicated portal. This comprehensive system manages new registrations, renewals, and benefit disbursements. The portal's integrated design allows workers to maintain access to their benefits even when relocating between states. It also enables seamless verification of worker credentials and employment history across multiple construction sites. Who can register as a building worker? Any worker who has completed at least 90 working days in building or construction activities within the previous 12 months qualifies for registration or renewal. Eligible workers include masons, carpenters, painters, plumbers, electricians, and various laborers directly involved in construction work. During registration, workers may need to provide documentation verifying their employment history in the construction sector. What do workers receive after registration? Upon successful registration, workers are issued a digital identification card featuring their photograph and essential personal information. If this digital ID is lost or damaged, workers can easily download a replacement copy from the registration portal. This digital ID serves as official proof of registration and is the key to accessing the full range of welfare schemes and benefits available to construction workers. What documents are required for registration? Workers must submit their Aadhaar card, active bank account details, valid mobile number, recent photograph, age proof, and address verification. Depending on state-specific requirements, additional documentation may include work certificates from employers or attestations from local authorities confirming their employment in the construction sector. What benefits are available to registered workers? Registered building workers gain access to numerous welfare schemes including comprehensive health insurance, accident coverage, educational scholarships for their children, pension plans, maternity benefits for women workers, and financial assistance for purchasing work tools. While specific benefits vary by state, the centralized portal ensures continuity of benefit eligibility and disbursement across state boundaries, regardless of where the worker is employed. Unorganized workers registration. FAQs. Unorganized workers must register on the government portal using Aadhaar to access benefits from various welfare schemes. Regular updates of personal information are essential for maintaining eligibility, and multiple stakeholders including state governments and employers are responsible for facilitating the registration process. How do I register as an unorganized worker? Register using your Aadhaar card on the government portal. Your Aadhaar must be linked to your mobile number to receive OTP verification during the process. The central government has developed dedicated mobile apps and websites for your convenience. Access the eShram portal, eshramgov.in, or download the eShram app from Google Play Store or App Store. Submit your personal information, occupation details, and bank account information through the portal to establish eligibility for benefit programs. Upon successful submission, you will receive a universal account number, UAN, and a digital eShram card that can be downloaded or accessed via SMS. What benefits will I get after registration? Registration enables access to numerous government welfare schemes including health insurance, accident coverage, maternity benefits, and pension programs. Benefit packages vary by state government regulations. Some states provide additional financial assistance, educational scholarships for children, and specialized skill development programs. Registration on the central government portal is mandatory to qualify for any benefits. Your eShram card serves as official verification when applying for these programs. All registered workers automatically receive accident insurance coverage of up to 2 lakh under the Pradhan Mantri Suraksha Bima Yojana (PMSBY). Do I need to update my information regularly? Yes. Periodic updates to your registration details are required. It's advisable to review and refresh your information at least annually. Updates should include current address, job classification, mobile number, and skills. Documenting newly acquired skills or profession changes ensures access to relevant schemes. Failure to maintain updated information may result in benefits disqualification. Outdated details could lead to application rejection or processing delays. The portal provides a simple update mechanism by logging in with your registered mobile number and UAN.
Who is responsible for helping workers register? State governments, welfare boards, employers, job providers, aggregators, and contractors have responsibility for facilitating worker registration. They may organize dedicated registration camps or provide assistance through common service centers. If you lack ESIC or EPFO registration, these entities should support your eShram portal registration with necessary documentation and technical guidance. Trade unions, worker associations, and NGOs also play an important role in assisting workers throughout the registration process, particularly for those with limited digital literacy. Common Service Centers, CSCs nationwide are officially designated to provide registration assistance at a nominal fee. What documents do I need for registration? Aadhaar card is mandatory as the primary identity verification document. An active mobile number linked to your Aadhaar for OTP verification during registration and future communications. A recent passport-sized photograph for your digital eShram card. Bank account details to receive direct benefit transfers from government schemes. What should I do if I face technical issues during registration? Contact the eShram Help Desk at toll-free number 14434 for immediate technical support. Visit your nearest Common Service Center, CSC, where trained operators can resolve registration issues. State labor departments provide additional support through designated district help centers. Consult the eShram portal's dedicated help section for comprehensive FAQs and troubleshooting guides addressing common problems. Gig and platform workers registration. FAQs workers age 1660 with at least 90 days of work in the previous year must register via Aadhaar on the designated portal. Companies are required to share worker data and integrate their databases to facilitate registration, enabling workers to access vital government benefits. Who needs to register as a gig or platform worker? Individuals between 16 and 60 years old who have completed at least 90 work days in the previous 12 months. This includes ride-sharing drivers, delivery personnel, digital platform freelancers, and anyone performing flexible, short-term jobs through online platforms. How do workers register? Registration requires Aadhaar verification through the dedicated online portal via mobile app or website. The process is self-declaratory and involves submitting personal details, work history, and skill information through a simple application form. What documents are needed for registration? An Aadhaar card serves as the primary identification document. Workers should also have ready access to their bank account details, mobile number, address proof, and relevant work information to complete the registration process. What responsibilities do aggregators have regarding worker information? Aggregators, platform companies, must submit monthly worker details to facilitate registration number generation. They must maintain comprehensive, up-to-date records of all gig workers, including work hours, payment information, and job classifications. What additional obligations do aggregators have? Aggregators must integrate their databases with the registration system and assist workers with Aadhaar-based identity verification. They're also responsible for informing workers about registration requirements, providing registration support, and ensuring full regulatory compliance. Why is registration beneficial for workers? Registration provides access to government welfare schemes and social security protections, specifically designed for gig workers. It formally acknowledges work status, opens pathways to skill development programs, and ensures eligibility for financial assistance during crises. How frequently should registration information be updated? Workers should update their information promptly after any significant change in personal details or work profile. At minimum, a yearly review and confirmation of registration information is recommended to maintain benefit eligibility. What are the consequences of not registering? Unregistered workers risk losing access to specialized government welfare schemes, social security benefits, healthcare provisions, and financial assistance programs, specifically designed to protect the livelihoods of platform-based workers. Gig workers contribution collection. FAQs contributions from aggregators are collected by government-appointed officers, deposited into a dedicated Social Security Fund account, and subject to statutory penalties if delayed. Aggregators must adhere to a specific payment schedule and reporting protocol established under the regulatory framework. Who collects contributions from aggregators? The central government designates an authorized officer or agency responsible for collecting and dispersing contributions from aggregators. This appointed authority has the legal mandate to request any necessary information from aggregators to facilitate the collection process. The officer possesses statutory powers to verify contribution calculations and enforce compliance with established regulations. Where does the money collected go? All contributions are deposited directly into the Social Security Fund. These funds are maintained in a segregated account specifically earmarked for gig and platform workers as stipulated in Section 141. This dedicated accounting ensures that all collected funds are exclusively utilized for the welfare programs and social security benefits of gig workers. What happens if payments are late? Aggregators failing to make timely payments incur financial penalties. The statutory penalty comprises a 1% interest charge assessed monthly on the outstanding amount until full payment is received. This interest continues to accrue on the entire unpaid sum without limitation. Chronic non-compliance may trigger additional regulatory enforcement actions. How do aggregators make payments? Aggregators must calculate their contribution obligation using Form XX remit a provisional payment by June 30th of each fiscal year, submit a finalized return using Form 21 by October 31st, following the audit of their financial statements, process all payments electronically through the government designated portal, preserve comprehensive records of all contributions for a minimum period of 5 years. How is the contribution amount calculated? The contribution amount is determined as a prescribed percentage of an aggregator's verified annual turnover. The central government establishes and periodically reviews this percentage rate. Aggregators are required to utilize Form XX for calculating this amount based on their independently audited financial statements. Are there any exemptions available for certain aggregators? Yes, the central government may grant exemptions to specific categories of aggregators, based on predetermined criteria, such as organizational size, workforce volume, or operational business model. However, exempted entities must nonetheless complete registration and fulfill all mandated reporting obligations, even when financial contributions are waived. What information must aggregators include in their reports? When filing Form 21, aggregators must provide comprehensive documentation of their annual turnover, precise count of gig workers engaged during the reporting period, detailed methodology employed for calculating contributions, itemized list of any claim deductions or exemptions, verification from an accredited accountant or independent auditor. Social Security Fund. Frequently asked questions. The Social Security Fund combines contributions from multiple sources, operates under government oversight with transparent management, undergoes regular independent auditing, and maintains dedicated accounts for specific worker categories. Where does the money in the Social Security Fund come from? The fund receives contributions from two primary sources: collections under Section 141 of the Social Security Code, and funds allocated through Section 115 of the Workplace Safety Code. Supplementary funding comes from government grants, private and public donations, and interest earned on investments. This multi-source approach ensures long-term stability for Social Security benefits. Who manages the Social Security Fund? The central government oversees the fund through a designated agency that maintains comprehensive records of all transactions and provides regular reports to the government. This agency adheres to strict financial protocols established by the Social Security Code. A diverse governing body, representing various stakeholders, supervises all operations to ensure accountability. How do we know the fund money is being used properly? The Comptroller and Auditor General of India conducts independent verification of all fund accounts. Annual audit reports are submitted to Parliament and made publicly accessible, ensuring complete transparency. The managing agency must promptly address any irregularities identified during these audits, creating a robust accountability system. What happens to the contributions collected from gig work platforms? These contributions are maintained in a dedicated account within the Social Security Fund. This segregation ensures funds are specifically available for gig and platform workers' benefits. The separate accounting enables tailored benefit programs that address the unique Social Security needs of gig workers without diversion to other purposes. How are benefit amounts determined? Benefit calculations consider multiple factors, including contribution history, prevailing economic conditions, and benefit type. Expert committees advise the central government on periodic reviews and adjustments to ensure benefit structures remain adequate and sustainable. All calculation formulas follow transparent methodologies published in official notifications. Can workers track their contributions and benefits? Yes, digital platforms provide full transparency as mandated by the Social Security Code. Workers can monitor their contribution history, benefit eligibility, and payment status through secure online portals or mobile apps. Each contributor receives a unique identification number for account tracking, with physical statements available for those without digital access. What safeguards exist to protect the fund from mismanagement? The fund is protected through multiple security layers, including regular internal audits, external oversight by the Comptroller and Auditor General, parliamentary supervision, and judicial review mechanisms. Management must follow conservative investment guidelines that prioritize security over returns. Stringent criminal penalties for fund misappropriation and whistleblower protections further strengthen fund integrity. Common questions about Social Security exemptions. Organizations can qualify for Social Security exemptions by providing superior benefits, meeting eligibility criteria, and following proper application procedures. Maintaining exemptions requires timely renewal applications and ongoing compliance. Here are answers to frequently asked questions about exemptions from Social Security provisions. What qualifications are needed for an exemption? Your organization must demonstrate that it provides benefits equal to or better than standard benefits. You must have a proven 3-year compliance record, at least 500 contributing members, and financial stability. Additionally, you must show sufficient administrative capacity to manage benefit distributions and maintain comprehensive fund transaction records. What is the application process? Applications can be submitted online or through alternative channels. Chapter 3 exemptions require employee consent, and all member accounts must be linked to their Aadhaar numbers. Your application package should include comprehensive documentation of your current benefit structure, 3 years of financial statements, and official certification confirming statutory compliance. How are exemptions renewed? Submit renewal applications at least 6 months before your current exemption expires. Chapter 4 exemptions can be extended for up to 5-year periods, provided you continue to meet all requirements. Include an updated compliance report, audited financial statements, and verification that your benefits continue to meet or exceed minimum standards. What is the timeline for application review? The central board or corporation should provide their assessment within 6 months. The government may extend this period if necessary. If no opinion is issued within the specified timeframe, the government may proceed independently. During review, continue operating under your existing exemption terms until you receive official notification. What if organizational changes occur during an exemption period? Notify the appropriate authorities within 30 days of significant changes such as mergers, acquisitions, or major restructuring. Your exemption status may require reassessment to confirm continued eligibility. Failure to report such changes could result in exemption revocation. Under what circumstances can exemptions be revoked? Exemptions may be revoked if your organization fails to maintain required benefit standards, experiences financial instability, or violates compliance requirements. You will typically receive prior notification outlining deficiencies and a reasonable time frame for corrections. If remedial measures prove inadequate, your exemption will be canceled, necessitating transition to the standard Social Security framework. What ongoing reporting is required? Exempted organizations must submit quarterly and annual reports detailing fund performance, benefit distributions, and statutory compliance. These reports require certification by authorized officers and may undergo random government verification. Any significant benefit structure modifications require pre-approval before implementation. Common questions about exempted establishments. Exempted establishments must maintain comprehensive records, submit periodic reports, adhere to scheme regulations, implement proper governance structures, and fulfill ongoing compliance requirements to maintain their valuable exemption status. Key requirements for exempted establishments. What must businesses with Chapter 4 exemptions do? Organizations must maintain detailed records of all exempted employees, submit regular compliance reports to the corporation, and apply for a new exemption if ownership changes through mergers or acquisitions. These records must include comprehensive employment histories, contribution details, and benefit distribution documentation. For thorough audit purposes, what are the duties for businesses with Chapter 3 exemptions? Organizations must strictly adhere to all provisions outlined in the relevant schemes and establish a properly constituted Board of Trustees to oversee the Provident Fund or Pension Fund as mandated by the central government. The board requires equal representation from employers and employees to ensure equitable fund administration. Why must records be maintained? Meticulous record-keeping ensures transparency and regulatory compliance, facilitating efficient verification by authorities that exempted establishments are fulfilling their statutory obligations. Proper documentation also safeguards both employers and employees by establishing a verifiable audit trail for all financial transactions and administrative decisions. What happens if a business doesn't fulfill these obligations? The exemption may be revoked, requiring the establishment to transition to standard Social Security programs and potentially incur significant penalties for non-compliance. Additionally, the organization may be liable for interest payments on delayed contributions and face heightened regulatory scrutiny and oversight. How often must exempted establishments submit reports? Exempted establishments typically must submit monthly, quarterly, and annual compliance reports detailing contributions, investment performance, benefit disbursements, and administrative expenditures. These reports require certification by authorized signatories and may necessitate independent verification from external auditors. What investment regulations apply to exempted funds? Funds administered by exempted establishments must strictly follow government-prescribed investment patterns. These include specific diversification requirements, exposure limits across asset classes, minimum return thresholds, and prohibition of certain high-risk investments to ensure long-term fund security and financial stability. Can exempted establishments modify their benefit structure? Any proposed modifications to the benefit structure require prior approval from appropriate regulatory authorities and cannot reduce benefit levels below the statutory minimum requirements. All changes must be formally communicated to members with mandated notice periods as specified in the governing regulations. Trust management for exempted establishments. FAQs exempted establishments must form a board of trustees with equal employer-employee representation, chaired by the employer, meeting quarterly and following government mandated guidelines for investment, fund management, and administration. Essential information about trust management for establishments exempted under the scheme. Who serves on the Board of Trustees? The board requires an equal number of employer and employee representatives as mandated in the schemes. This balanced composition ensures equitable decision-making for all stakeholders. Employee representatives must be selected through a transparent nomination or election process conducted among fund members. Who chairs the board meetings? The employer serves as the chairperson of the board. In case of a tie during voting, the chairperson holds the authority to cast a deciding vote. The chairperson must maintain impartiality during all proceedings and ensure comprehensive documentation of all board decisions. How frequently must the board convene? The board is required to meet at least quarterly, once every 3 months. All meetings must comply with guidelines issued by the central government or commissioner to maintain proper governance. Urgent matters may warrant special meetings, provided all trustees receive proper notification. What regulations govern board operations? The relevant schemes detail all operational parameters, including trustee tenure, election procedures, disqualification criteria, quorum requirements, and record-keeping protocols. Additionally, the board must strictly adhere to government-prescribed investment patterns and guidelines. What investment duties do trustees bear? Trustees must ensure prudent fund investment according to central government-specified patterns. They must conduct regular performance reviews, assess investment risks, and verify compliance with all regulatory requirements regarding permissible securities and exposure limitations. What reporting requirements apply to trustees? The board must submit regular reports to authorities detailing fund performance, membership updates, investment activities, and compliance status. Annual audited financial statements must be prepared and presented to members to ensure transparency and accountability. How are board disputes resolved? Unresolvable disputes may be referred to the Regional Commissioner or Central Provident Fund Commissioner for guidance or final decision. The scheme provides structured mechanisms for grievance resolution while ensuring the trust's continued functioning. Financial accounts and irrecoverable dues. FAQs financial accounts must be balanced annually, by March 31st, with statements prepared by May 31st. While the corporation or board possesses the authority to write off unpaid dues that satisfy specific criteria for being deemed irrecoverable. When can unpaid dues be written off? Unpaid dues qualify for write-off when the business has ceased operations for more than 5 years, and the employer remains untraceable despite diligent location efforts. No recoverable assets exist after exhausting all legal recovery procedures, or only partial claims can be recovered in cases of company liquidation or nationalization. Any write-off decision requires comprehensive documentation and thorough verification of these conditions. Who has the authority to write off unpaid dues? The corporation or board holds the power to write off contributions, cess, interest, and damages deemed irrecoverable. This authority operates through a structured resolution process requiring detailed documentation of recovery attempts, verification of irrecoverability, and approval at appropriate management levels. Cases involving substantial amounts trigger enhanced scrutiny and specialized approval procedures. How are financial accounts maintained? The corporation must maintain comprehensive and accurate accounts as mandated by regulations. All transactions require proper recording with supporting documentation. The accounting system must adhere to standardized accounting principles and practices prescribed by relevant authorities. Regular internal audits ensure compliance with accounting standards. All financial books must be balanced by March 31st annually, marking the financial year's conclusion. When must financial statements be prepared? Revenue accounts and balance sheet preparation must be completed by May 31st annually, allowing the corporation 2 months after the financial year's end to compile, review, and finalize all accounts. Extensions may be granted for exceptional circumstances, provided requests include written justification. Financial statements must follow prescribed formats and present a true and fair representation of the corporation's financial position. The audit process follows a structured timeline with annual accounts submitted by June 15th, internal committee review and corporation approval by December 10th, and final submission to Parliament through the central government by December 20th. Common questions about audits and financial oversight. When are annual accounts submitted for audit? Annual accounts must be submitted to the Comptroller and Auditor General by June 15th each year. The auditor is authorized to request documents, summon individuals for questioning, and collect statements to conduct a thorough audit. Missing this deadline may trigger compliance notices and potential penalties under financial regulations. What does the audit report cover? The audit report verifies that the balance sheet presents a complete and fair view. It confirms that financial statements are properly prepared and accurately reflect the corporation's financial position. The report incorporates any explanations provided by the corporation, examines internal control mechanisms, assesses compliance with relevant laws, and evaluates adherence to established accounting standards. How are audit reports reviewed internally? The Standing Committee initially examines the annual report and audited accounts. Subsequently, these documents are presented at a corporation meeting for approval by December 10th, provided the audit report is received by November 20th. During this review, committee members may seek clarification on specific financial items, question accounting methodologies, or recommend corrective measures for identified issues. Where do the final reports go? Following approval, the reports and accounts receive the corporation's official seal. They must be transmitted to the central government by December 20th, which then submits them to Parliament. Upon submission to Parliament, these documents become part of the public record and may undergo further scrutiny by parliamentary committees specializing in financial oversight. What happens if discrepancies are found during an audit? When auditors identify discrepancies, the corporation must provide written explanations within 14 days. Significant issues may prompt a special audit or investigation. The corporation must implement corrective actions and document these measures in subsequent reports, with verification occurring in the next audit cycle. Who can access audit reports? Once submitted to Parliament, audit reports become public documents available to stakeholders, researchers, and citizens under transparency provisions. However, certain commercially sensitive information may be redacted in public versions. The corporation is required to maintain archived copies of all audit reports for a minimum of 7 years. What is the role of external auditors versus internal financial controls? External auditors provide independent verification of financial statements, while internal controls constitute ongoing processes designed to ensure financial integrity. The corporation must maintain both systems, with internal financial controllers conducting quarterly reviews and implementing recommendations from external audits. This dual approach establishes multiple layers of financial oversight and accountability. Employers must maintain comprehensive records, including women employee registers, preserve all workplace documentation for a minimum of 2 years, and submit unified annual returns electronically by February 1st annually. Frequently asked questions. Record keeping. How should I maintain records of women employees? You must maintain a register of all women workers in Form 22. This register can be kept electronically or in physical format. Ensure you record complete details of all women employees, and keep this register readily accessible for inspection upon request by authorized officials. How long must I keep workplace records? All records specified in Chapter 5 of the Code, must be preserved for a minimum of 2 years from their creation date. This retention period ensures documentation remains available for compliance verification and reference purposes throughout the statutory timeframe. When and how do I submit annual returns? You are required to submit a unified annual return electronically through Form 23 by February 1st each calendar year. In cases of business transfer, closure, or cessation of operations, you must file supplementary returns within 1 month of such organizational change. What specific information must be included in employee registers? Employee registers must contain comprehensive personal and professional information, including full names, permanent and current addresses, dates of birth, job designations, joining dates, working hour schedules, detailed wage calculations, and leave entitlement records. For women employees specifically, additional documentation regarding maternity benefits and related provisions must be meticulously maintained in Form 22. Are there penalties for failing to maintain proper records? Yes. Non-compliance with record-keeping requirements can result in significant penalties under the Code. Inspecting authorities may initially issue improvement notices, but persistent violations can trigger financial penalties ranging from $10,000 to $50,000, with the amount determined by the severity, duration, and frequency of non-compliance. Can I maintain digital records instead of paper records? Yes. The Code explicitly permits electronic record-keeping systems, provided they ensure instant accessibility, implement robust backup protocols, and can generate physical copies during official inspections. Digital records must incorporate appropriate cybersecurity measures, including access controls, encryption, and redundant backup systems to safeguard data integrity. Many organizations are adopting digital solutions to enhance record management efficiency, improve data analytics capabilities, and reduce physical storage requirements. Offense settlement requires responding to a Form 24 notice, paying the specified amount within 15 days, and receiving a settlement certificate, with non-compliance resulting in court proceedings. Offense settlement. Common questions: what happens when I receive a settlement notice? You'll receive a Form 24 notice from an authorized officer for offenses eligible for settlement without court proceedings. This process, known as compounding an offense under Section 138, includes details about the alleged violation and the settlement amount based on the offense severity. How do I respond to the settlement notice? Complete Part 3 of the Form 24 you received and pay the full amount within 15 days of notice receipt. Payment can be made online or through other approved methods. Retain copies of your payment receipt and completed form as proof of compliance. What documentation will I receive after payment? Within 10 days of payment, the compounding officer will issue a certificate, in Part IV of Form 24, confirming your case settlement. This certificate serves as legal evidence that you've resolved the matter and protects you from further proceedings related to this specific offense. What are the consequences of missing the payment deadline? Failure to pay within the 15-day time frame will result in your case being forwarded for court prosecution. Court proceedings typically involve higher costs, greater time commitment, and potentially more severe penalties if found guilty. Are all offenses eligible for settlement through this process? No. Only offenses specified under Section 138 of the Code qualify for settlement. Serious violations, repeat offenses, or incidents causing significant harm are generally ineligible for compounding and must proceed through standard court proceedings. Is there flexibility in the settlement amount? The settlement amount is typically fixed according to established guidelines, based on the nature and severity of the offense. In exceptional circumstances, you may submit a written request explaining special conditions that might warrant reconsideration, though the final determination remains with the compounding officer. Does settling an offense constitute an admission of guilt? While not technically equivalent to a court conviction, settling an offense through compounding does involve acknowledging the violation and accepting responsibility by paying the specified amount. Though the settlement prevents further legal action on this matter, it may be considered if similar violations occur in the future. Frequently asked questions. Career centers provide comprehensive employment services and career guidance through government initiatives or strategic partnerships with various organizations. Who can establish a career center? National, state, and local government bodies can establish and operate career centers to serve their communities. Existing employment exchanges can be transformed into career centers while preserving their essential functions. Until officially transformed through proper notification, existing employment exchanges will operate as career centers with identical authority and responsibilities. Transformation involves facility upgrades, staff training, and implementation of enhanced service protocols. Can other organizations operate career centers? Yes. the government can form partnerships with educational institutions, colleges, local authorities, NGOs, and private companies to operate career centers. These collaborations extend services to underserved areas and specialized populations. Partner organizations must adhere to government-established standards and guidelines. Partnerships may be structured as public-private initiatives, franchises, or contractual arrangements. What services do career centers offer? Collection and organization of job vacancy information from diverse industries and sectors, personalized career counseling and guidance from qualified professionals, organization of job fairs, recruitment drives, and employer-candidate matching events, research on employment trends, skills gaps, and labor market conditions, training programs for job skills, interview preparation, and resume building, specialized services for youth, women, persons with disabilities, and experienced professionals, maintenance of comprehensive databases to facilitate effective job seeker and position matching, assistance to employers with recruitment processes and candidate sourcing. How do career centers benefit the community? Reduction of unemployment through strategic matching of qualified candidates with appropriate opportunities, empowerment of individuals to make informed career decisions based on skills and market demand, support for economic development by connecting businesses with needed talent, provision of critical labor market insights to policymakers and educational institutions, vacancy reporting, FAQs. Employers must report job vacancies to career centers before filling positions. Specific timeframes and reporting locations vary based on sector, job type, and geographic requirements. Who needs to report job vacancies? All public sector organizations must report job openings before filling them. Private companies with 50 or more employees must report vacancies from the date specified in official notifications. Government-funded educational institutions must report both teaching and administrative positions. Government contractors working on projects above established value thresholds must report specialized positions. Organizations with special exemptions may have modified reporting requirements based on their operational nature. Where should I report different types of vacancies? Report technical and scientific jobs with higher compensation levels to the Central Career Center. Also report there when seeking candidates from outside your state. Report all other vacancies to your regional career center. International recruitment positions require reporting to both the Central Career Center and the appropriate international liaison office. Temporary positions under 6 months can be reported to local career center branches. Remote work positions should be reported based on the company's headquarters location, with clear notation of the position's remote nature. How much advance notice is needed for reporting? Regional career center vacancies require reporting at least 15 days before application deadlines. Central career center vacancies require 40 days advance notice. Emergency hiring situations may qualify for expedited processing with minimum 7-day notice, subject to approval. Seasonal positions in agriculture and tourism sectors require 30 days advance reporting due to high-volume processing needs. Position modifications or amendments must be reported at least 10 days before the original application deadline. Why is vacancy reporting important? Reporting connects job seekers with available positions and enables government monitoring of employment trends. It promotes fair hiring practices and helps reduce unemployment. It creates a centralized database that enhances job market transparency and accessibility for all candidates. Data collected through reporting helps develop targeted skill development programs addressing specific industry needs. Regular reporting contributes to accurate labor market statistics that inform policy decisions on education, immigration, and economic development. Employers benefit from wider candidate pools and potentially reduced recruitment costs through career center services. Employment information returns. Employers must maintain comprehensive employment records and submit annual returns to career centers. Compliance is monitored and enforced by designated executive officers who ensure adherence to reporting requirements. Key questions about employment information reporting. What records must employers maintain? Public employers must keep detailed records of all employees, new hires, position classifications, vacant positions, and projected future openings. These records must include complete employee profiles with qualifications, skill assessments, and compensation details. Private employers with 50 or more workers become subject to identical record-keeping obligations upon official notification. When and how do employers submit annual returns? Employers must submit Form 26 to their designated career center annually within 30 days after the end of the fiscal year March 31st. Submissions may be made either through paper filing or electronic submission, according to state government specifications. All forms must be completed in full with precise information and authenticated with an authorized signature from the organization, who oversees compliance with these requirements. The Director of Employment designates executive officers for district level and central career centers. These officials are responsible for monitoring employer compliance with all employment information reporting regulations. Their authority extends to conducting record inspections, issuing non-compliance notices, and recommending appropriate penalties for violations. What happens if an employer fails to submit returns? Non-compliance with reporting requirements may trigger penalties under relevant labor legislation. Executive officers have the authority to issue formal improvement notices, levy financial penalties, or recommend legal proceedings for serious or repeated violations. Before imposing sanctions, employers are generally afforded an opportunity to provide justification for any reporting delays. Are there any exemptions to these reporting requirements? Organizations with employee counts below the statutory threshold may qualify for temporary exemption until formal notification is issued. Businesses with seasonal operations may be eligible for modified reporting schedules. All exemptions require official authorization. An employer should consult their local career center to verify eligibility status. What information should be included in Form 26? Form 26 requires comprehensive organizational information, including business classification, ownership structure, workforce demographics categorized by skill level and gender, wage scales, workplace conditions, and employment forecasts. The form also requires detailed documentation of apprenticeship initiatives and vocational training programs administered by the employer. Unified Annual Return Format. Common questions. Employers must submit standardized annual returns detailing business information, workforce composition, registration data, working conditions, compensation, and employee benefits to demonstrate compliance with labor regulations. These comprehensive returns enable authorities to monitor employment practices and enforce labor standards effectively. What basic information must I provide? Include your company name, address, and contact information, along with your manager's details. You must also report your industry classification code, company size category, and the primary nature of your business activities for proper categorization. Which registration numbers are required? Provide all business registration numbers, including those for workplace safety, code on occupational safety, worker benefits, code on Social Security, and other applicable regulations. Your tax identification number, business license number, and any industry-specific registration codes must also be included. What employment details should I report? Document your business's operating days, total employee work days, hours of operation, and designated weekly rest days. Also include shift patterns, overtime policies, and any special working arrangements such as flexible hours or remote work options. How should I categorize different types of workers? Report the maximum number of employees during the reporting period, categorized by gender, age groups, and skill levels, skilled, semi-skilled, etc. Include specific information about contract workers, apprentices, part-time employees, and other special categories. For foreign workers, specify nationalities and work permit status as required. What wage information is necessary? Detail the pay rates for each skill level, the number of workers in each pay bracket, and payment schedules. Include information on minimum wage compliance, average departmental wages, bonus structures, incentive programs, and any collective bargaining agreements affecting compensation. Also report any wage revisions implemented during the period.